tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Bamora tanah airku yang tercinta, tempat beta dibesarkan ibunda. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya. Meski beta lama jauh di rantau orang, beta ingat mama janji pulangnya. Biarpun Tanjung Teluknya jauh tapi nusaku, tapi selalu terkenang di kalbuku. Anak timur main sasando dan menyanyi boleh leboh, rasa girang dan badendang pulangnya.
Ladies and gentlemen, allow me to announce the rules for participants in today's symposium. Participants shall join the room 15 minutes before the International Symposium is started. Participants shall change the name format participant underscore full name. Participants shall turn the video on, mute the microphone, and use virtual background. Participants may raise hand only in questions and answer session. Assalamualaikum warahmatullahi wabarakatuh. May peace be upon us all. Good morning, honorable speakers, distinguished participants, ladies and gentlemen. It's very pleased to me to welcome you back again to the 4th Indonesian Constitutional Court International Symposium. Today is the second day of this symposium, and we are going to hear 8 speakers delivering their ideas and their paper. And of course, all participants are welcomely and allowed to join the interactive discussions into the questions and answer sessions today. Previously, we have heard more than 20 interesting topics and of course a lot of thoughts about the theme that we discuss in these 2 days of symposium: Constitutional Court, Religions, and the Constitutional Rights Protections. With the same theme, of course, with a broader point of view, today we're gonna have more interesting topics and discussion. Ladies and gentlemen, I respectfully invite the moderator today to moderate the first sessions, who will be moderated by Mrs. Anantia Ayu, a researcher from the Constitutional Court of the Republic of Indonesia. But before that, let's again take a look further on the video of 4th ICCIS. Langsung ya.
The 4th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion, and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Good morning, ladies and gentlemen, speakers, participants, dear colleagues. Thank you for being here this morning. I hope you are doing well. My name is Anantia Ayu Devitasari. You can call me Ayu. Today I'm going to be your moderator in this opening session. Welcome to the second day of the 4th ICCIS. Yesterday we already discussed various perspectives on how state and religious dynamics relation and how court and religion can play an important role to protect constitutional rights of the people. I'm so delighted to see you here, and I'm looking forward to have a fruitful discussion with you as well. Today, we are pleased to welcome Associate Professor Dr. Christine Steiner. Hello, Dr. Christine Steiner.
Yes, hello, good morning.
Good morning. How are you today, Dr. Christine?
I'm fine, thank you very much, and delighted to be here.
Nice to meet you as well. And the second speaker is Dr. Andi Omara. How are you today, Dr. Andi Omara? I can hear your voice. Sorry.
I'm very good. And you?
I'm very good also. I'm looking forward to hear your presentation today. And the third speaker is Dr. Ahmad Rafi'i. How are you today, Dr. Ahmad Rafi'i?
Yes, good. I'm very well, thank you.
Very good.
Can you hear me?
Yes, I can hear you
good.
clearly. Okay. For the first presenter, I would like to invite Associate Professor Dr. Christine Steiner. First of all, I would like to introduce Dr. Christine Steiner is an associate professor at the Law School Latrobe University and senior associate at CILIS, as well as associate at ALC, both at the University of Melbourne. She specialized in the Southeast Asia legal studies and researches on the intersection of law, politics, economics, and society, especially with regard to Islam. She has held numerous visiting positions and presented her research extensively at a range of highly prestigious national and international institutions and conferences. Dr. Steiner has various notable publications in the area of Islam, law, and human rights, include volumes on Islam, law, and the state in the Southeast Asia. Very wide range of portfolio here. I'm very looking forward to hear your presentation. Dr. Christine Steiner, the floor is yours. I'm sorry.
I was muted, so I had to reset. I do apologize. Technical problems early in the morning. Well, good morning, honorable judges, colleagues, ladies and gentlemen. I would like to start by thanking the conference organizers for going ahead with this great conference. And getting us together, albeit virtually, in order to exchange our ideas, research, and what is going on in our respective areas. Finally, I would like to also thank them for the kind invitation to this event today. And moreover, I would like to thank you for coming at this early hour. So thank you so much. My presentation picks up from some of the threads and ideas that were explored in the previous sessions yesterday. And that is the advantage of not being the first to go, even though I am the first today. I have the pleasure of building up on some of the things my esteemed colleagues, especially Dr. Dian Shah and Professor Dr. Shuaib, explored yesterday in the context of Malaysia. So my presentation will address the question as to why the pendulum swings, as it was characterized yesterday. I will look at this not only in the context of Malaysia, but also Singapore and Brunei, thus expanding it to the common law countries in the region, which share similar legal systems, and also one important characteristic, that is having no constitutional court at all. I will trace how these legal plural systems conceptualize the state-religion relationship in the absence of the constitutional court, and moreover, the impact it has on the protection of constitutionally enshrined rights. I will start by discussing the two different models of legal pluralism in which systems are either seen as autonomous or interacting, and in which overlap interests exist. This is followed by a discussion of the state-relationship, which will assist in answering the question of normative ordering within these legal plural systems. The last section will contextualize how these theoretical conceptualizations play out in the context of Singapore, Malaysia, and Brunei. Asia, and indeed Southeast Asia, is an extremely diverse region. And in order to accommodate this diversity and arguably give credence to the special position of certain religions, one common feature in Southeast Asia is that of a plural legal system. The plural legal system is nearly always caused by the acknowledgement of a specific religion and thus establishing a religious legal system next to the secular, civil, non-religious system. So there are different ways in which the perceived dichotomy between those systems can be described. So in order to keep it short and simple today, I'm going to call them secular system. I do acknowledge and stress that there is a significant question mark as to whether this is really secular or not. So there are two models of how this legal pluralism can be constructed. The autonomous legal plural system is a choice of law based on legal pluralism, where everything can be categorized into either belonging to system A or system B. This still has credence for the study of post-colonial legal systems, though, with changes to Malaysia's legal plural system and especially Article 121(1)(a), creating two parallel, relatively autonomous legal systems. The interacting legal pluralism reflects life, in my humble opinion, as matters can sometimes be hardly placed into neat boxes, especially if these boxes are operating on a binary, one or the other notion. The next section will contextualize how these considerations are playing out. So, the state-religion relationship. The states of Singapore, Malaysia, and Brunei have all in common that upon obtaining independence, they had to negotiate their own approaches of accommodating and controlling Islam in their respective legal and political frameworks. Ranhirsche sets out three prototypical ways in which this relationship could be conceptualized. Constitutional secularism, which may be accompanied by enclaves of religion-based jurisdictional autonomy. State endorsement of religion as a source of national heritage and a marker of collective identity, and strong establishment of religion, so-called Islamic constitutionalism. These three systems answer the question of normative ordering that are raised by legal pluralism. That is, how are disputes sorted into different legal systems? And normative hierarchy, or the dominance between those legal systems. The interesting part is that these prototypes are not categories that are mutually inclusive, but they are really a continuum where we can see certain constitutional provision swimming, again, like a pendulum from one side to the other. So how does that play out in the context of Singapore, Malaysia, and Brunei? Well, Singapore was a crown colony where sovereignty rested with the British, and as such, religion was not the source of sovereignty. Indeed, Islam was subordinated to political power of the British colonializers, and this approach continues well into post-independence time. I'm not going to discuss the short-lived relationship, marriage, with Malaysia upon independence. Like any relationship that ends in divorce, well, there has been a lot of finger-pointing and allocating blame as to whose fault it is. Suffice to say that Singapore is extremely conscientious, suspicious, and carefully manages religion. Some people might even call it paranoid. So Islam was to be accommodated within a secular system, restricting religion to the personal sphere and consequently limiting Islamic law to private legal matters. The Singaporean state has assumed what has been described as the paradoxical role of the secular state in determining the interpretation of Islam in Singapore. It is paradox because the secular state is imposing a system of management of religion, and it becomes directly involved in determining religious behavior. Subordinating religion to political need is, for instance, evident in the Tudong discourse and whether girls attending schools and or employees are allowed to wear it. So what does this mean for our question of legal pluralism and normative ordering? On the one hand side, the jurisdiction of the Sharia courts in personal matters is confined to disputes where both parties are Muslims and married under Muslim law. And while in 2008, the jurisdiction of the Sharia courts was increased to also cover certain personal matters such as marriage expenses and the registration of divorces, it on the other hand conferred concurrent jurisdiction on the secular courts and the Sharia courts in matters of maintenance, custody of children, and disposition of division of property on divorce. In order to avoid a multiplicity of actions, proceedings should stay in the High Court in certain circumstances, and the High Court will then apply civil law to determine the questions of custody and access to children and the division of matrimonial assets. This makes it a plural legal system where interaction is possible and indeed encouraged by the state. These changes have been met with critical reception by the Muslim minority, who consider this a way to opt out of their religion if convenient, a permission to go forum shopping, an extension of the civil law to Muslims, or even worse, a return to colonial times where non-Muslims were adjudicating on Islamic legal matters. Indeed, this preference of the secular system is also evident in how the secular courts are treating Islamic law. There are numerous cases where an officially sanctioned, authorized fatwa was set aside and as such treated like any expert opinion on civil law and thus not binding on the secular courts. Compare this to Malaysia, where at the outset, it is important to note that unlike Singapore, the constitution assumes that the plural legal systems are autonomous from each other in general. This can be interfered through the constitutional provision that gives the Sharia court exclusive jurisdiction over limited subject matters, such as Islamic personal law and Islamic criminal law, and where people are professing the religion of Islam. This sets it up for the binary system of legal pluralism, where one legal system wins over the other. As we all know, statutory interpretation is an art form, and as such, it is no surprise that the different courts have favored different interpretations of this over time using three different approaches, based respectively on the remedy involved, the subject matter, that is looking at the explicit or implied jurisdiction, or the subject. In 2006, the High Court in the Federal Territories in the Morty case interpreted Article 121(1)(a) of the Federal Constitution to offer the broadest interpretation yet of the jurisdiction of the Sharia courts. It expanded the implied subject approach and ruled that the secular courts had no jurisdiction in Islamic matters, even when a non-Muslim was concerned, and that a non-Muslim had no remedy at all under common law if a decision had already been made by the Sharia courts. Moreover, a litigant might face being significantly criticized, as it happened to Subhashini at the Court of Appeal. She was accused of, and I quote, wanting the civil court to deal with her problems. The appellant, Subhashini, had attempted to convince us that a civil court has the jurisdiction and the knowledge to deal with her matter, even though imbued and intertwined with thick strands of Islamic elements. In short, the appellant wanted the civil court to abrogate the function and duties of the Sharia court, regardless of the litigant's right of choice, let alone he had already made his decision. Quote ending. Well, Subhashini was a non-Muslim and her constitutional rights were at risk. That begs the question, where should she have gone? At the other spectrum is the more current jurisdiction, where higher courts have accepted jurisdiction. For instance, in the case of Indira Gandhi mentioned yesterday, with the very similar facts to the case of Subhashini. Here, the Judicial Commissioner confirmed that the Constitution is supreme and that the civil courts are appropriate forum for grievances concerning the Constitution. The High Court decision, however, was overruled by the Court of Appeal, but was finally settled when the Federal Court confirmed the High Court's decision in 2018. Yet, this binary option is not the only way in which the normative hierarchy or the competency and hierarchy among the legal systems can be resolved. Indeed, in Malaysia, disputes concerning Islamic banking and finance challenge this binary system and instead have seen a more cooperative approach between civil courts where the matters are adjudicated and the National Sharia Advisory Council, which decides on matters of conformity with Islamic law. It took decades to develop that system, but it does solve quite pertinent issues. It is avoiding that non-Muslims are deciding on matters of Islamic law, while on the flip side, the expert in civil and or constitutional law rule on their own law. And it avoids that Islamic legal expert opinions are discarded like in Singapore. Let's take a look at Brunei now. Now, Brunei is one of the few absolute monarchies in the world, and the Constitution of 1959 did not provide for separation of powers, nor did it provide for the protection of human rights or individual freedoms. The power of the Sultan are further cemented by the perpetual state of emergency that Brunei has been in since 1962, and which has been continuously renewed. In Brunei, Islam is part of the Brunei Malay Muslim Monarchy, MIB, which conflates sovereignty and political legitimacy with the Sultan, Islam, and Malay identity. To a certain degree, the underpinning ideas of MIB are a continuum from the colonial period. Now, theoretically, Brunei is a plural legal system in which civil non-religious law operate next to Islamic law. There are, however, certain anomalies that are not worthwhile noting. Singapore and Malaysia have provisions that explicitly state that the jurisdiction of the Sharia courts are limited to people professing the religion of Islam, even though not always adhered to, as we've seen. However, the new Sharia Penal Code 2013 is also applicable to non-Muslims. This means that we have Sharia courts that now explicitly have jurisdictions over non-Muslims. For the human rights situation, it is as such that the Constitution does not contain any fundamental or civic rights. And Brunei is or has been described as the most reluctant ratifier within Asia of human rights. This is because MIB has been elevated to the official state ideology, and since independence, the government consistently rejects, in particular, ideas of liberalism, which are arguably closely connected to international human rights and related to civic liberties.
Dr. Christie?
Now concluding. So which way does the pendulum swing? The problem lies at the outset with the conceptualization of legal pluralism. Setting it up as a diametrically opposed binary autonomous system does not reflect reality. And with all respect to the esteemed judiciary, it also opens it up to different interpretations, which does not provide certainty and clarity for litigants. Moreover, in the case of constitutionally enshrined human rights, it can leave people stranded in no man's land, as seen in some of the Malaysian cases. Having an interacting plural legal system reflects reality, but also then necessities that the interacting system is setting up clear rules as to which legal system looks at what matters. I'm a firm believer that you should leave it to the respective experts to make these determinations on the substantive matters of their laws. So I would not want a Sharia judge to rule on constitutional matters, nor would I like to see a civil judge make rulings on Islamic law. Instead, a system has to be cooperative, where those matters are then transferred for determination towards authorized experts. Their decision should not be discarded lightly and indeed should mostly be adhered to. This compromise would work in secular system and also in system where state is enshrined in this constitution. It might also be a way in which countries with Islamic constitutionalism can take certain constitutional aspects into account, even though religion would overrule the constitution. Thank you so much.
Thank you so much. Thank you so much for the insightful presentation, Dr. Christine. It is offer a new perspective considering we have Constitutional Court as a final interpreter of the Constitution and sometimes define the relation between the state and religion. In the absence of Constitutional Court, the conceptualize of the relation between state and religion involving plural state actors and the dynamics can be different depending on each legal system. For further comment, I would like to invite my colleague and fellow researcher, Helmi Kasim. Okay, to Helmi Kasim, the floor is yours.
Thank you very much, Sayo. Good morning from Bandung, Dr. Steiner. Thank you very much. I am honored actually to be in this session to listen and try to comprehend your insightful interpretation. I am aware that you have written extensively on this topic, and in this opportunity of mine, this is not a response actually. This is a question to explore more, just to allow you more time to talk on this interesting topic. But to provide a brief background, because we have studied extensively in comparative ways between Malaysia, Brunei, Philippines, and Singapore, I would like to provide a brief comments on Indonesia concerning a debate on religions, rights, and the Constitution. In Indonesia, the debates on religion has actually started since the preparations of Indonesian independence itself, especially when our founding fathers discusses the foundation of the state, which is Pancasila. The first principle is belief in the one and only God, but this is actually a change from previously discussed principle stated in Jakarta Charter, Piagam Jakarta, which reads, believe in one and only God, with the obligation to adhere to practice Islamic Sharia for its adherents. But this was contested by the so-called nationalist groups. And despite the struggle from the Muslim communities, the Muslim groups at the time, but this provision called the 7 words was removed from the approved versions of the principles in the Constitution. So this debate has been started since then, including also the debates concerning the incorporation of human rights in the Constitution. Our founding fathers, some of them disapproved to incorporate human rights provisions in the Constitution because our state is founded on the principles of the so-called social justice, not individual justice as recognized in the principles of human rights in the Western perspective. So this debate has started since then. With the birth of the Constitutional Court, in the development of Indonesian constitutional system, in the amendment of the Constitution, which lasted from 1999 2002, in fact, the Constitution incorporates extensively, comprehensively the provisions of human rights. One chapter is dedicated to regulate human rights in our Constitution, chapter 10A. Which include, I think, everything which is stated there in the International Bill of Human Rights. So the human rights is widely recognized and accepted in Indonesian Constitution, despite the previous debate during the preparations for independence among our founding fathers. And also, with the birth of the Constitutional Court, we notice also how the Constitutional Court tries to balance the position between religion and state. In its decision, the court stated that Indonesia is not a religious state, which is based on only one religion, but also not a secular state, which leave the religious matter simply become a matter of individual rights of the citizen. But the state used national law to integrate these systems, these various and diverse perspectives. Using the approach of your study from comparative perspective, what actually this reflects? With this brief descriptions, of course, I hope that someday I would read your writing on Indonesia about Islam, human rights, and the constitutions of Indonesia. I would expect that very much. I previously have explored your writings, and I tried to find out what you say about Indonesia actually with its current systems of with the current development in our constitutional system. And also based on this constitutional perspective, actually, in this diverse system, diverse view, what is actually the point of convergence between Islam, the legal system, and the constitution of each state? What is actually the point of convergence? I think that's my questions actually, Dr. Steiner. I would like to hear more of your interesting opinions on this topic. Thank you very much, Ayu.
I see that my colleague here want to hear more lecture from Dr. Kirsten.
I couldn't be more pleased. I think in all my years, I've never had such a kind respondent to my paper. So thank you so much for this. Also, your queries to delve into the Indonesian situation. I have to confess, when I was invited, I had similar apprehension than some of my previous colleagues that I mentioned that yesterday. And I thought, well, what can I tell them about constitution and rights? The Europeans have a saying, this is like taking owls to Athens. And the assumption is there are a lot of owls in Athens. So I was actually feeling extremely daunted. And then I thought, well, I'm on safe grounds if I'm sticking to the common law countries, even though you've given me the perfect opportunities to comment on some of my very preliminary ideas on Indonesia, because while I've been looking at Indonesia in some contexts, it hasn't been the focus. And I apologize, because you've got a beautiful countries and I'd love to come back again and do more studies there. So I think taking that opportunity, there are a few things where the situation in Indonesia has got, or what I've discussed, has got some certain impact on Indonesia. Particularly your question on the Islam and state relationship. Because if you are looking at Jan Hirschel's model, I would place both Malaysia and Indonesia in the system where we do have a state endorsement of a religion. Now, whether we are going to the Pancasila and we are taking the plural religions, or if we are going with the Jakarta Charter and we are only taking one religion. And by the way, at some stage, I'd love to go into this whole conspiracy theory on the Jakarta Charter and the Pancasila, but that's a different matter. So it does tell us a lot about the relationship between state and religion, because with this endorsement comes the question then of normative ordering. That is, if we have a plural system, and I'm assuming that we can agree that life is messy. So I'm discarding the autonomous system and we're going with the overlapping one, right? So if we have these problems, particularly when it comes to the constitution, and in Malaysia, we do not have a constitutional court, then the question becomes on who's the final arbitrator on the constitution? Who has the final say on the interpretation of the constitution? and how it should be conceptualized. And as we can see in the case of Indonesia and Malaysia, on looking at the constitution and how it's constructed, there have been massive disputes on this. So Jakarta Charter versus Pancasila. In the context of Malaysia, well, are we a secular state or not, right? This is a massive ongoing debate, and whenever you feel bored and don't know what you want to write, you can write an update on where the current political regime stands on the spectrum of this never-ending saga. So if we are looking at these systems that have the constitutionally enshrined preference for religion, the question is then, where do these matters go when it comes to constitutional rights? For you, it should be relatively easy, I believe, because they should really go to a constitutional court. In the absence of a constitutional court, I am a firm believer that they should go in the secular courts, because for me, these constitutions, while they are enshrining a religion, are still state-based. That means they derive their authority from the state, and as such should stay with the secular state system. The problem is when we don't have that clear framework. And this is what we've seen in Malaysia, where the pendulum of the courts really swings from one way to the other, where we see secular courts refusing to accept jurisdiction over the constitution, and people are left in no man's land with nowhere to turn in order to get justice, if I may say so. So that is the biggest problem. And this is particularly when we are looking at matters of religious freedom. So all the cases that we've discussed in Malaysia so far throughout this yesterday and today, that is Subhashini, Shamala, Indira Gandhi, those are cases where we had people getting married under secular laws, and then the husband, and I'm very sorry to say, it's always the husband who converts to Islam and seeks a divorce. Just to be non-discriminatory to gender, in the Philippines, it's the other way around. So in the Philippines, I've come across cases where the woman converts to Islam in order to seek a divorce, but that's a different topic. And that leaves then in the Malaysian context, the woman who is not a Muslim with the expectation in some instances to go to the Sharia courts. And the question is that really the right forum for them? Or should they, if they have concerns regarding their constitutional rights, should they not be looked after in the secular system? I hope this answers some of your questions and provided a bit more of an explanatory framework.
Okay, discussing relation and how to balance diffusion of state and religion, especially in the absence of constitutional court, can take a whole week. I personally look further to discussing this theme in another event with Mas Helmi and Dr. Kirsten. Thank you for the comprehensive speaker and respondent. Big applause for Dr. Kirsten Steiner. Now we are going to proceed to our next speaker, Dr. Andi Amara. Good morning, Dr. Andi Amara.
Good morning. Am I audible?
Yes,
Okay.
I can hear you clearly.
Okay, shall I start?
I would like to introduce you to...
Okay, thank you.
So Dr. Andi Amara is an associate professor of constitutional law at Gadjah Mada University, School of Law, Yogyakarta, Indonesia. He graduated from Gadjah Mada University and Master of Public and International Law from University of Melbourne and PhD from University of Washington. His primary research area are Indonesian constitutional law, Indonesian legislative process, judicial review, the Indonesian judiciary comparative constitutional law, and human rights. Recent publication includes Spritzer and so forth. So I think as most of the researchers already read the publication and books by Dr. Andi Amara. It's not a new name for us. So without further ado, Dr. Andi Amara, the floor is yours.
Okay,
And
thank you very much,
the committee, before you proceed your presentation,
moderator,
I'm
Miss
sorry.
Moderator. So,
The committee will operate your PPT, and you can
okay,
say,
thank you.
move on to the next slide. Okay.
Okay, good. Okay, thank you very much. First of all, I would like to thanks for this very wonderful international symposium. Thank you for the Constitutional Court of Indonesia for hosting this very important event. So my presentation today will talk about, I think this is back to 1945 debate. So why not Indonesia is an Islamic country? And I will address and try to answer this question by looking at the method, how actually the drafter of the constitutions take an approach on resolving this very problematic problem. So this is my outline. When I'm talking about why Indonesia finally not become an Islamic country or state, then I will look at some of the important reference. So I will first present my research questions, and then I will explain three important literature review. I will look at first about the state-religion relations in the constitutions, and then I will also look at the literature on constitutional making process. And then moving on, I will look at literature on constitutional deferral. So am I the one who operating this slide, or let's keep moving?
The committee will operate that slide, and you can say next to the.
So I'm still in a second slide.
Is the committees?
The second slide. Before this slide. Another slide. Before this slide. Okay, thank you. So this actually the one that, okay, thank you very much. So this outline shows that I want gonna talk. So the first I will talk about the research questions that I raised, why I try to respond these questions, or why it is important to have this question in place. And then the second, third, and fourth, I will look at some important and relevant literature on state-religion relations, on the constitutions, and then constitutional making process, and then constitutional deferral. And this constitutional deferral is important because I will look at how actually the constitutional drafter tried to address this very, what we call, important provisions, yet it is very difficult to get an agreement. And then the fifth, I will discuss the background of the drafter of the constitutions, and I will try to answer whether the background of the drafter is actually also influence the way the constitution is drafted. And then I will also look at how actually we understand the approach adopted by the constitutional drafter in writing or drafting the article on state and religions relations in the constitutions. And finally, I will draw conclusions. And this, next, please. Next slide, please. And my research question is actually, why didn't the constitutional drafter declare Islam as state official regions or mention Islam explicitly in the constitutions, despite the fact that Indonesia is a Muslim majority country? What explains the above facts? And then moving on the next slide, I will show you that there are some literature on how actually to map the relations between state and religions in the constitutions. We can see state with an official religions, which mean that their constitutions expressly mentions religions, and then state with prefer religions, in this case the government, through its policy actually is in favor one religions over others. And then the third is state with no preferred religions, and then finally state with hostile relations toward religions. Next, please. And then in similar context, we can also see how actually literature on state and religion relations. And from Idea International, it says there are three different relations: strong secularism, weak secularism, or state neutrality, and then pluralist accommodations and recognitions without establishment. So when we look at these two different literature, we can see that there are some models how actually the relations between religions and state. And of course, I will look at how actually the Indonesia fit in this four different typologies. And then on the next slide, we will see the literature on constitution making process. And in this case, I will look at who actually the drafter of the constitutions, when to make constitutions, and how to make constitutions. And this actually become important because sometimes there are some variations when we talk about who the drafter of the constitutions and when should be making constitutions and how. Sometimes when we talk about who, should the constitutions made by those who expert on this, or should it include many segment of people, meaning that it should goes in participatory way. And then when to make constitutions, some scholars says that it should made in political maturity, meaning that in calm, peaceful, and in conducive situations. But when we look at the reality, specifically when we talk about Indonesia, our experience teach us when we draft new or amended constitutions, it's normally begins by a crisis, political crisis or economic crisis. And then the final literature that I want to use is actually literature on constitutional deferral. And this actually important because I will primarily use this approach to understand how actually the Indonesian founding fathers debate, negotiate, and finally decide the article as well as the preamble of the constitutions, which mentions about the 7 words that Michael already mentions in the previous presentations about the Piagam Jakarta. And when we talk about the constitutional deferral, it basically means that there is a tendency, in certain circumstances, there is a tendency that the constitutional drafter will include somewhat abstract and general provisions as opposed to go to the detail when they draft their constitutions, because this approach will potentially achieve the agreement rather than when they go to the detail. And the constitutional deferral in this case can be seen in 3 different forms. The first is adopting vague constitutional language. Second, using specific language that expressly delegate issues to lawmakers. And finally, stipulating 2 or more constitutional provisions which basically in conflict. And then now we move to the context of Indonesia. Who actually the drafter of the first constitutions of Indonesia? If we look at the body who prepare and draft the Indonesian constitutions, we can see that, of course, this is not an ideal committee. It is not based on democratically elected body, but when we see, it somehow provides some what we call diversity. As we can see from the slide, there are 63 individuals of the committee. And then when we look at the background, in terms of their ethnicities, religions, as well as educations, it's varied. Even though when you look at the ethnicity, we can see that Japanese is the majority. With regard to the religions, Muslim or Islam is the majority. And when you look at the educational background, there are varied, but some of them is actually Western Europe or Dutch educational system. They have the background from Dutch educational system as well as Western Europe's. And then when we look at the profile of the constitutional drafter, we may see that it probably will influence the way the constitution will draft it, right? Because Islam is the majority and then Javanese is the majority. But we can see, and in the next slide, how actually the drafter introduced article on religion-state relations. We can see that at least there are two differing views on how actually we should draft the constitutions which explain about the relations between religions and state. The first says that it is important to mention Islam, but the other group says that it is not necessary to refer to a particular religions and stated expressly in the constitutions, right? And as already mentioned before, this basically discussions on the Jakarta Charter. And there are some proposals. So Jakarta Charter basically not only talk about ketuhanan yang Maha Esa or believe in one Supreme Court, but also dengan kewajiban menjalankan syariat Islam bagi pemeluknya, with the obligations to live according to Islamic law for Muslim. And this 7 word is basically become the point where they disagree. So when drafting constitutions in the context of the first constitutional drafter, we can see that it's not only the preamble, there are also some suggestions to include Islam in Article 4 and Article 29. Specifically, when we talk about the president and vice president should be or shall be Muslim, or Article 29 with also talk about the 7 words or the Piagam Jakarta. And on the next slide, we can see how actually this arguments goes. For Islamic group, it is important to mention specifically or expressly in the constitutions because the fact that Indonesia actually, the populations of Indonesia, 90% of the population are Muslim. And then Islam, according to the Islamic group, also says that Islam will respect and protect other religions, and Islam regulates many different aspects of life. What about the other groups? For nationalists and non-Muslim, we can see that it is not necessary to mention specifically Islam or to pick a reference Islam in the constitutions. And this actually supported by the nationalists, Sukarno and Hatta, and they basically also Muslim, and also some non-Muslim PPUPK members. So they argue that while Muslims are majority in Indonesia, but there are also other religions existed in Indonesia. And for now, for 1945 period, the most important thing is actually to keep the unity of Indonesia, and finally we can gain our independence. That's their argument. And then in the next slide, we can see how this difference can be reconciled. So while in the beginning, the introductions of Jakarta Charter in the preamble seems to be accepted by everyone on the committee, but later on, these 7 words become problem. And the question is how to bridge these 2 differing views.
Excuse me, sorry to interfere, Dr. Andi Amara.
Yeah.
Your time is limited, so can you please jump into the conclusion?
Okay. Okay, so to reconcile such different, I think the constitutional drafter used what I call, or what the Dixon and Ginsburg called as constitutional deferral, which means that they still refer to religions, but not specific religions. They use the term religions, but not Islam. And this result in the deletion or the abolishment of 7 words of Piagam Jakarta. And when we look at the method that they use, they do not go to the detail, but instead they use the abstract and vague term that can be the common ground to achieve an agreement. And finally, in the conclusions, I will say that the reasons why the drafter did not particularly adopt specific religions in the first constitutions because there are differing views on this regard, and the insert of 7 words potentially create problem. That's why they draft abstract and general provisions in the constitutions and not to go to the detail, and this will help the drafter to achieve consensus. And I will say that this approach is reflect constitutional deferral. I think that's all for my presentations, and thank you very much.
Thank you very much for the insightful presentations. You introduced us to the concept of constitutional deferral, because the debate on Islam in the country has a lot of embellished the history of this nation. And Dr. Andi Amara elaborated a comprehensive analysis using historical approach and constitutional deferral. And I see that the united conversation playing important role of the outcome of the characteristic on general and abstract incorporated religion in the Constitution influences by the drafter of the Constitution. For further comment, I would like to invite my colleague, Saka Firma Aditya. Can you hear us, Saka Firma Aditya? Saka, the floor is yours.
Yeah, thank you, Ms. Moderator. Give me the opportunity to respond to Dr. Andi Amara presentation. I enjoy your presentation, and it's a brilliant paper. It's valuable knowledge for me and the participants, especially Indonesian, who are still curious about why Indonesia is not Islamic State. I'm also inquisitive why did not the Indonesian constitutional drafter declare Islam as the state official religion despite Indonesia being a Muslim majority country. Whereas at that time, in 1944, almost 90% of Indonesian population was Muslim. So if we look at the composition of the founding fathers in the framework of the BPUPK, almost 55 of the 63 members are Muslim. I agree with your paper that although most BPUPK members are Muslim, the Japanese colonial government was selected them. Therefore, the committee composition is somewhat diverse, including their religions and ethnicities. Also, educational background of the BPUPK members is also diverse. The majority of the BPUPK members had been educated in Western Europe or had attended school based on the Dutch educational system. Although I agree, but actually I also have a different perspective. First, if we look at the composition of BPUPK members, there are actually many members who are ulama and have the title of Hajj. For example, we know Agus Salim, Abdul Halim Majalenka, Mas Mansur, Mashkur, Ahmad Sanusi, Abdul Rahman Baswedan, and others. All of them are ulama who have considerable influence in society. They also have many connections with Muslim countries in the Middle East and Africa. So it is not surprising that the first countries to recognize Indonesia independence were Muslim countries such as Egypt, Lebanon, the Kingdom of Saudi Arabia, Syria, and Yemen. Furthermore, in history, it turned out that Muslims initiated by the ulama mostly carried resistance and movement against the colonial. The Dutch colonial government gave the title Hajj to mark and alert Indonesians who broached the spirit of pan-Islamism after returning from Saudi Arabia. In fact, the Dutch colonial government are worried about the political impact of the Hajj because people who return from Mecca are accepted as holy people in Java. It is believed that people who has the title Hajj are heard by other ordinary people, so that the Dutch colonial government makes strict regulation relating to the Hajj. Based on this argument, it seems very impossible if the spirit of pan-Islamism did not bring to the BPUPK discussion or debating and they separate the state from religion. So in your opinion, was there a political barter between Muslim and non-Muslim or ulama and nationalist members, so they agree to separate religion from the state? It's my first question. Second, after the independence proclamation, various movements emerged that want to establish an Islamic state. For example, we know the Darul Islam and Indonesian Islamic Army Rebellion in Aceh, West Java, Central Java, South Sulawesi, and South Kalimantan. Its rebellion was motivated by the dissatisfaction of Islamic group toward the form of the state, which tend to be secular. It is also indicated that the agreement to form a unitary state by separating religion from the state actually create a new problem. In fact, at that time, when Pancasila is contradicted with religion, there are Islamic groups that demand the return of the 7 words that were omitted from the Jakarta Charter. So, in your opinion, how to solve this problem? Because this movement will always exist and develop in the future. And thirdly, although the founding fathers have separated this religion from the state, but the nuances of Islam are actually very attached. In the constitutional structure, for example, Indonesia has a Sharia court, Sharia law, the Ministry of Religion, Sharia Bank, the Indonesian Ulama Council or MUI has the Amil Zakat Agency, has a compilation of Islamic law and others. And then in daily life, Muslim community always say Assalamualaikum when they meet each other, or Alhamdulillah when they get pleasure. So in your opinion, it is possible for Indonesia to become an Islamic state without declaring itself in the constitution? It is my last question. Thank you, Ms. Moderator. Assalamualaikum warahmatullahi wabarakatuh.
For the insightful comment and respondent. So Dr. Andi Omara, the floor is yours to answer the comment.
Okay, thank you very much, Mr. Respondent. So I will go to the final question first. So is it possible to categorize or to include Indonesia as Islamic or religious country without mentioning in the constitutions? So with that regard, I would go to my fourth slides. For me, I agree with this literature review saying that state would prefer religions, meaning that the government through its policy is favor one religion over others. It's not necessarily talk about whether state, whether the constitution expressly mentions in the constitution, whether the religions or particular religions mentions expressly in the constitutions, but I would say state with preferred religions, meaning that through its policy, government is favor one religions over others. That would be my first questions, my first response to respond to your final questions. Regarding the what we call never-ending discussions on seven words or Jakarta Charter, I do agree that when Hatta deleted the seven words, not everyone agree basically, right? Some BPUPK members actually dissatisfied because in the previous meeting they already agreed with the mentions of seven words. But again, there is a a danger of putting seven words in the constitutions, because some eastern part of Indonesia will decide will not join Indonesia. Even though I also find an article which says that, is it true? Then the eastern part of Indonesia will not join Indonesia if Islam is actually put in the constitutions. But that would be the argument why the drafter finally dropped the seven words. And I do also agree there are some dissatisfactions, or they're not satisfied with the result. And Sukarno tried to convince them by saying, now is the important thing is we have constitutions. And then we still consider this constitution as a temporary constitutions. And we still have some times in the future to amend these constitutions to make the democratic permanent constitutions, which you may also put your idea in that process. But it's never happened. I mean, it's not never happened, but it is getting difficult to put their agenda there, right? So the political party in this case, I think I don't see what we call this. For me, the political party would be, it is not officially or constitutionally recognized in the constitutions, but somehow the policy of government is actually in favor of Muslim in area that you mentioned, right? Assalamualaikum, and then we can see Menteri Agama, like I think Gus Nasir said that should we have the what we call Hajj pilgrimage department or perjalanan keagamaan, because there are some other religion which also have perjalanan keagamaan or the religious trip or journey. So, and the questions regarding Islamic movement, how we deals with this what we call potential problem in the now and future. I think the idea of what we call idea of establishing an Islamic country domestically still become a problem, but I think most of Indonesians, I don't say all, because there are small groups which also still try to stipulate or try to put agenda on Islamic movement, but I think that's part of democracy. But somehow, how to deal with this, I think by providing or educating and then providing, showing the fact that Indonesia is diverse in many ways. And we also shows that there are many examples abroad how we can learn from the practice in other countries. I think that would be my response on your questions. And again, I also haven't what we call address the background on Hajj and then ulama. I think that's also important. And I also found that there are also some important figure in the BPUPK which have the background of Islamic organizations in their background. I think, thank you very much. That's very enlightening and broadening my perspective in improving this paper.
Thank you very much to Dr. Andi Amara and our respondent. It is interesting to note that the debate of founding father that takes decades ago affecting the relation, state, and religion in Indonesia today. Thank you for the fruitful and insightful presentation from Dr. Andi Amara. Big round of applause for you. And now we are going to proceed to our next speaker. Good morning, Dr. Ahmad Rofi'i. Can you hear my voice clearly? Hello. Good morning, Dr. Ahmad Rofi'i. I can hear your voice clearly. Can you unmute your Zoom? The committee, please help Dr. Ahmad Rofi'i to unmute the Zoom.
Okay, now it's done. That's right.
Perfect.
Good morning. Thank you.
First of all, I would like to introduce you to the participant and other speakers. Good morning. Dr. Ahmad Rofi'i is a lecturer at State Institute of Islamic Studies, Cirebon, Indonesia. He holds a PhD in law from Monash University, Australia. He received his bachelor degree and master degree in Islamic law from UIN Syarif Hidayatullah, Jakarta. His second master degree is in law from the University of Melbourne, Australia. His research covers Islamic law and Islamic legal theory, the relationship between constitutionalism and religion, Indonesian constitutionalism, and comparative legal studies. He also has published journal articles on Islamic law, Islamic legal theory, and comparative constitutionalism. Dr. Ahmad Rofi'i, are you ready? The floor is yours. And you can ask the committee to operate the PPT, and you can say next to the next slide.
Okay, good morning, everyone. Thank you, Ms. Moderator, for a generous introduction. My today's presentation is about the whether the Indonesian Constitution is a religious constitution. Let me begin by saying a few about the place of religion in Indonesian Constitution. The place of religion in Indonesian Constitution seems to be significantly important, particularly after the amendment, as there is an increasing number of references to the religion related words in the amended Constitution. For example, these words are to be found in the preamble, Article 9, 22T, 24 to 28A, paragraph 1, 28I, 28J, 29, and 31. Because of this, the previous Chief Justice, for example, Professor Chimley, characterized the Constitution as very religious and godly at the same time, or what Professor Mahfud MD, also former Chief Justice of the Constitutional Court, called religious, establishing a religious nation state. With such significant reference to religion, can Indonesian Constitution be meaningfully categorized as a religious constitution? Next slide, please. The religious constitution is used here as a category distinct from its rival, the secular constitution. Professor Christine and other speakers has already explained about many views regarding constitutionalism. But here I will use religious constitution and secular constitution as different. While secular constitution is constitution which establishes separation of state and religion, the religious constitution makes religions the basis of government. The religious constitution established a religion or some religions as the only recognized religions. My presentation will discuss the received theory of the religiosity of the Indonesian constitution. I will focus on the adoption of the religious values clause in the chapter of human rights and how this clause has been interpreted by the Constitutional Court. Next slide, please. Even though human rights are believed to be fundamental to Indonesian constitutionalism, for drafters of Chapter 10A, human rights were always considered subject to limitation. This limitation, according to Article 28A, paragraph 2, are legitimate, provided they are determined by legislation with the sole purpose of guaranteeing recognition and respect for the rights and freedom of others, and of meeting just requirements based upon consideration of morality, religious values, security, and public order in a democratic society. The text is similar to Article 36 of the Info Decree of 1998 on human rights, with a particular exception, namely the phrase religious values. When the idea of human rights was first debated during the constitutional amendment, following the discussion on citizen and presidents, the reformative faction of the NPR suggests the inclusion of religious values in line with the principle of belief in one supreme God, Ketuhanan Yang Maha Esa, as a limiter of human rights. The agreed first draft chapter, however, did not make any such reference to religious values. They were then proposed again on the basis that they would constrain the unbridled exercise of freedom and the excessive enjoyment of rights. The reformative faction initially proposed the inclusion of the word religious values directly after legislation as a limit of rights, which might be understood as that religious values would have authority equivalent to that of the statute in limiting rights. Notwithstanding this, the matter of religious values was again left absent from the second draft chapter. Next slide, please. Aware of this failure, I am Lutfi of the reformative faction complained and reminded other members about religious values. Instead of placing them immediately after legislation, the suggestion now is on religious values are placed immediately after morality consideration. Some members from the secular nationalist faction, then IPORI faction and PDIP faction opposed this inclusion. On the other hand, other members, particularly from the Muslim-based party-based faction, support the idea, arguing that the inclusion was a means to perfect morality consideration and to elucidate the contents in accordance with the religious nature of the nation. All factions, for their own reason, finally agreed to the insertion of the ruling on religious values. Next slide, please. Although religious values were introduced and supported by the Muslim-based faction, which were implicitly aiming to advance Islamic aspiration, these words use religious values rather than Islamic values, and their final adoption by faction from different political ideologies and religious affiliation demonstrate the inclusiveness and generality of the meaning of the words religious values. The religious values clause is therefore different from religious supremacy clause in Islamic constitution. The term religious values are also ambiguous as they entail different understanding from various religious worldviews and their different schools or denomination. A reasonable meaning of the word religious values, therefore, should refer to values of religions which are general and universal enough that they would reasonably be accepted by various religious traditions. The word values was not crafted accidentally. It was deliberately chosen so that all NPR faction could agree with the insertion of the term religious values. By employing the word values, the consideration of the limitation of rights should refer to more general doctrine and principle of religion rather than its rules and practical norms. Here I refer to the distinction between principle and rules. What could be the role of religious laws in the face of religious values laws? Religious law, Islamic law in particular, could have different roles in the face of religious values laws. It could act as an object of rights limitation. The exercise of the right to manifest religious freedom in the form of implementation of Islamic law might be subject to a state restriction whose legitimacy is determined by its consistency with, among others, religious values. In other words, the values of all religions. Can the religious values clause provide a basis for religious law, particularly Islamic law, to be considered limiting rights? The possibility of Islamic values, par excellence, being the grounds for the limitation of rights would be adopted only in the case of limiting legislation, which is specifically binding for Muslims only, and it should be understood in values, and Islamic values, not law, not rules. In cases of legislation concerning the right of all religious believers, the consideration of religious values should be general and inclusive of the values of all religions. Next slide, please. Thank you. Because the limitation of rights is possible only if it is provided by legislation, the determination of whether the legislation fulfills the requirements of legitimate limitation, including by religious values, is left to the authoritative interpreters of such legislation, the Constitutional Court, not the religious authority, in accordance with the principle of the supremacy of the Constitution. It is up to the court then to decide whether a legal restriction on the manifestation of religious values, for instance, is consistent with religious values or and other ground of for right limitation. In addition, religious values are not standalone values based on the same principle of the constitutional supremacy. The reference to religious values, Islamic legal principle, or other requires conformity to the values and principles of the Constitution, particularly as established in the preamble. Now, having discussed the making of religious values laws, now I will turn to the next question of how the Constitutional Court, as the most authoritative interpreter of the Constitution, has viewed any implication of the laws for the religious character of the Constitution. I will answer this question through analysis of the court decision in the religious marriage case. The case concerned the constitutionality of Article 2, Paragraph 1 of the marriage law, stating that the validity of marriage is determined by the respective religious laws of the marrying couples. The marriage law set the religious foundation of marriage in Indonesia. Many provisions of the law demonstrate strong religious influence. The law is silent on the status of interreligious or interfaith marriage. Since the promulgation of the law, interreligious marriage has been subject to some different and even conflicting treatment by the government. The case brought before the court was mainly motivated by the impact of this provision on the legitimacy of interreligious marriage. Next slide, please. This is all the arguments of the applicants. Basically, it's there that the article contravenes many constitutional rights and also the constitutional provision of rights limitation. Next slide, please. The court rejected the application and upheld the constitutionality of Article 2, Paragraph 1. Although there was no disagreement with respect to the judgment, Justice Maria Farida gave a separate argument which, putting aside her concluding judgment, in fact criticized the marriage law, particularly Article 2(1). There are 2 points I would like to make regarding the court's decision. The first point is it is significant about religious significance of marriage. In its defense of the religiosity of marriage, the court referred to the 4th paragraph of the preamble in Article 29, paragraph 1 of the Constitution, in which the phrase "belief in one supreme God" is entrenched as a state ideology. As the court pointed out, this reference suggested the constitutional acknowledgement of religion. As a consequence, the state acknowledged that the acts of citizens would be closely related to religion. Throughout the argument, the court emphasized the religious character of marriage. The reference only to the first principle of the Pancasila, I argue, indicate judicial support of religious supremacy, an approach of strong religious constitutionalism. Such a reference raised a foundational problem of marriage, while the single principle, excluding all others, provide the basis for justifying marriage. Marriage might also be approached from the point of the second principle of Pancasila, just and civilized humanity, meaning that marriage is part of human rights and collective human expression. The court did not give a definition or criteria of what religion is for the purpose of the validity of marriage. Unlike the decision of the case, the blasphemy law and local beliefs, the court did not address here, in this case, did not address whether the word religion should be inclusive. Next slide, please. In this case, the court did not address whether the word religion should be inclusive. If the court refers to the marriage law and the existing practice of legitimate marriage, it would be most likely to cause a very restrictive concept of religion, to the effect that marriage would be valid only if it were conducted according to the practice of recognized religion. By limiting marriage to religious marriage, the court seemed to be suggesting that everyone, even a non-religious person, has to marry according to a religion. Despite the fact that the court dealt with the constitutionality of Article 2(1, it did not mention that the law engaged with the main concern of the application and all the submission, namely the validity of interreligious marriage. By being silent on this matter, the court seemed to maintain the existing ambiguity of the legal status of interreligious marriage, leaving it to the government to regulate and consequently making it vulnerable to various restrictions or to being uncertain of protection. The second point is about the limitation by religious values. Against the argument of the applicants that Article 2(1 restricted their right to establish a family for legitimate marriage, the court referred to a limitation clause to the effect that the limitation created by the impugned article was justified. How this consideration could justify this limitation, however, was not further elaborated.
Sorry,
the fact that the limitation, yes.
I would like to remind you the
Yes.
time. Okay.
Yeah, just a few. Okay, that the court gave emphasis to the role of religion in the limitation of rights, although it is not the sole consideration for the limitation of rights to marry. The consideration of religious values is likely constitute the most important point of reference. However, the court did not elaborate it further. Next slide, the last slide. In fact, there are some relaxation made to religious marriage exclusivism through the registration of marriage between persons of local beliefs, a fact that the Constitutional Court failed to acknowledge. The court did not, although the religion plays an important role in the court decision, the court religious reasoning is absent from the court's justification of religious marriage. My argument here is that the religious consideration could be acceptable in a constitutional argument. The main problem is how such consideration remain consistent with constitutionalism. In the matter of marriage validity, the court has so far accepted exclusively religious determination. Nevertheless, the question is whether religion itself necessitates the fulfillment of religious requirement for a marriage to be religiously legitimate. The fact this is not the case. The limitation of the right to marry for the basis of religion, I argue, in the case of Islam, is not supported by religious law itself. By that, I end my presentation. Thank you very much.
Thank you very much for our presentation. Interesting to highlight how religious value interpreted and incorporated by the legal reasoning from our decisions. Furthermore, in addition, religious value are not standalone values. It should be requires conformity to the values and principle of the Constitution. It is interesting notes. And for further comment and respond, I would like to invite my colleague and fellow researcher, Lutfi Chakim.
Hello, moderator.
Okay, I can hear your face clearly. The floor is yours to give a comment.
Thank you very much, moderator, distinguished speaker, participants, ladies and gentlemen. My name is Lutfi Chakim. As a moderator said, I'm a researcher here at the Constitutional Court of the Republic. Thank you very much, Dr. Ahmad Rafi'i, for bringing us the wonderful discussions about the religious values clause and its interpretations. I really enjoy reading your paper with around 32 pages. So I have at least 3 issues that I can bring up for the discussions. The first issue is about the religious values clause in the constitutions. And the second issue is about your critically analysis of the Constitutional Court decision in the interpretation in the interreligious marriage case. And the last one is about the human rights limitations in the freedom of religions. First one, religious values clause in the constitutions. Your paper not only investigate the doctrinal but also historical implication of the religious values clause in the 1945 constitutions. But I have interesting issues that you mentioned in your paper. You mentioned about the constitutional theocracy. This phrase actually used in connection with the Iranian government in 1987. If I read several references, for example, Ran Hirschels, a professor from the University of Toronto Law School, has written more than one article discussing on the constitutional theocracies. So one of these articles entitled Constitutional Court and versus Religious Fundamentalism, Professor Ran Hirschels has expanded on the distinctions between constitutional theocracies and democracies. And these issues, in the first issues, what I ask you is that, can you elaborate more about the constitutional theocracy when it comes to the Indonesian constitutions? And the next issues is about your critical analysis on the Constitutional Court decision in the interreligious marriage case, which is the decision number 68, year 2014. The case was in 2014. One of the applicants is Damian Agata Juvens. He brought their application to the Constitutional Court to review the constitutionality of Article 2, Paragraph 1 of the marriage law. However, the Constitutional Court rejected the application and argued that despite the constitutional recognition of the right to marry, the Constitution allows limitation on the exercise of the right through the legislation, which mentioned the Article 28J, Paragraph 2. And you mentioned at least 4 critical points based on these Constitutional Court decisions. First one, you mentioned about the court didn't give definitions of criteria of what religion is. The second one, your point is the court overemphasized on the role of religion in marriage. Third, the court didn't mention the validity of interreligious or faith marriages. The last point of your critique is about the interreligious marriage legitimacy. So what I'm gonna ask you is that, how should the Constitutional Court judge or decide freedom of religion cases in the future judgment? This can be a fruitful reference or suggestion to the Indonesian Constitutional Court when the court deal the same cases in the future judgment. The last issues is about the rights limitations. You know that the limitations on the right to marry and the right to refuse religion, as is mentioned in your article, you mentioned 2 limitations. The first one is the limitation on the right to marry and the limitation on the right to religious freedom. However, in this case, the Constitutional Court referred to the limitation clause, which mentioned in the Article 28J, Paragraph 2, which mentions that the limitation of right is possible only if it's provided by legislations made to protect rights and freedom of others and consistent with the consideration based on morality, religious values, safety, and public order. So can you give us a standard or criteria how state could limit the freedom of religions, the right to freedom of religions in Indonesia? For example, when take looks from the other countries, for example, the German Federal Constitutional Court and the Korean Constitutional Court apply 4 steps of proportionality analysis when they want to limit the freedom of religion cases. The first step is the legitimate purpose. The second step is the suitability. Third, necessity, and last one, a balance test. So can you propose or can you explain more detail in which what standards or criteria that can be used to limit the right to freedom of religion in Indonesia? So these are 3 issues that I'm going to raise in this session. So please, I will give it back to the moderator and Dr. Ahmad Rafi'i for the next discussion. Thank you very much.
Thank you for comprehensive response and comment, Lutfi Chakim. For Dr. Ahmad Rafi'i, the floor is yours.
Thank you very much, Dr. Chakim. That's very interesting and challenging comments. I'm starting from the first issue that you raised about the constitutional theocracy. I use these words in the same sense as the religious constitutionalism. So you can look at what Professor Barker write about theocratic constitutionalism. So theocratic constitutionalism or constitutional theocracy, it just I use it in the same way as the religious constitutionalism. And Professor Hirschel, as you already mentioned, has identified there are a few criteria about what is religious constitutionalism, or we can say it also the constitutional theocratic constitutionalism. And one important criteria is that it's the constitutional theocracy is making religion or religious law in particular as the basis of the governance. So religious law as is the most, or the main basis, the main reference of the state law. So that the main criteria of the democratic constitution. This is of course different from what we generally understand about the theocracy, in the sense that there are a clergy who rules the state. So it's about the rule of religious law. Theocracy here means the rule of religious law. That's for the first issue. And the second issue is about how should the court judge in this case. In my opinion, of course, it's let the judge think and justify whether the marriage validity, the religious marriage exclusivism, what I call that, is consistent with constitutional rights of religious people and non-religious people. But maybe I just can recommend about the possibility of having, for example, conditionally unconstitutional or conditionally constitutional decision for this matter. Because if we just adhere to religious marriage exclusivism, as I argue in my paper, it will many constitutional rights of Indonesian citizens will be denied, because it's non-religious people or non-recognized religions, right? They will suffer from this religious marriage exclusivism. And the third, the last issue, I think it's you already mentioned the answer. So yeah, as far as I know, the court did not have any established method of interpretation regarding the limitation of rights. By referring to other constitutional jurisprudence, as you mentioned, Germany, for example, or South Africa, maybe we can use that steps of how the constitutional right can be limited, and for example, by referring to proportionality analysis, and that's yeah. In many writers also has mentioned about the using of proportionality analysis in the court decision. That is not consistent, and also, in my opinion, also I have read the case the court decided regarding the blasphemy law. On the concurring opinion of Justice, I forgot his name, but he used proportionality analysis to argue against the case.
I'm sorry, Doctor.
Yes, I think, yeah, that's all.
Thank you very much. It's a wonderful discussion between the speaker and the respondent, but unfortunately, the time has ended. Thank you very much for the insightful presentation for speaker. Actually, there are Q&A session, but unfortunately, again, the time ended. It is wonderful discussion. I would like to appreciate one last time for speakers, Dr. Kirsten Steiner, Dr. Andi Omara, Dr. Ahmad Rofi'i, fellow respondent and participant who joined this insightful discussion. Big round of applause for all of us. This is the end of our session. I return to the MC now.
Thank you very much, Mrs. Anantia Ayu, as the moderator for the first panel sessions for today's symposium. Ladies and gentlemen, we are going to listen to the second panel or the second discussion sessions. Then I would like to invite Mr. Mahrus Ali to lead the next session or the next discussions. Mr. Mahrus Ali, the time is yours.
The 4th Indonesian Constitutional Court International Symposium, ICC-IS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion, and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, distinguished speaker, participant of the ICCI 2021. My name is Muhammad Maharus Ali. You can call me Ali. I'm a researcher of Indonesian Constitutional Court. Allow me to moderate the 6th panel session with 3 speakers and 2 respondents. First of all, I would like to invite the 3 speakers. First is Dr. Hairil Azmin Mukhtar. And then, hello, good morning. How are you today?
Yeah, good morning.
Thank you, Dr. Hairil Azmin Mukhtar. And the second is Mrs. Chekli Setya Pratiwi. Hello, good morning. How are you today?
Assalamualaikum, I'm fine, thank you.
Waalaikumsalam. Thank you. And the last speaker, Mrs. Tri Sulistani Astuti. Hello, good morning. How are you today?
Good morning, Pa Ali. Nice to see you. I'm fine, thank you. How about you?
Thank you. I'm fine too. Okay, we're glad to have you here. And to shorten the time, I would like to introduce the first speaker. Dr. Hairil Azmin Mukhtar from the International Islamic University of Malaysia is a senior law lecturer teaching at Ahmad Ibrahim Kuliah of Law, International Islamic University of Malaysia. She has been teaching undergraduate and postgraduate students for more than 28 years in various law courses, including constitutional law, administrative law, human rights, comparative law, comparative constitutional laws. Today, Dr. Hairil will present the article under the title Unmasking the Devil, the role of court and Islamic religious authorities in the battle against religious extremism and terrorism in Malaysia. Okay, to shorten the time, Dr. Hairil, you have 15 minutes to present your article. The floor is yours.
Thank you very much. Can I share the screen?
Yes. The committee will assist for share screen.
Still disabled. Okay, all right, thank you. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much for the invitation. And I very much would like to present on the topic, which is, I think, is very important for everybody, because this topic actually concerns us. Okay, the topic is relating to the misuse or abuse of religion. So the title, as you can see, is Unmasking the Devil, the role of the court and Islamic religious authorities in the battle against religious extremism and terrorism in Malaysia. So basically, my idea is to discuss about the religious rights under the Malaysian Constitution. And basically, I'm going to proceed to look at how the rights is limited, and basically how the limitation is very important in order to preserve public order and security. And also, I'm going to look at the mechanism used by the Malaysian authorities, especially the Islamic religious authorities, in controlling religious extremism in Malaysia. Okay, now Malaysia is a country which is proud of its multi-religious, multi-ethnic, and multicultural characters. So religious freedom is an important aspect of this democratic nation. And freedom of religion is one of the fundamental liberties guaranteed and protected by the federal constitution. Respect and understanding are vital in preserving the peace and harmony of the various races and religion living in the country. So in Article 11 of the federal constitution, it is proclaimed that every person has the right to profess, practice, and propagate his religion. And this right can be claimed by anybody irrespective of religion, citizen, gender, ethnic group, or others. However, the sanctity of religion has been undermined by a group of people who seem to have vile intention. Not only these people deleted the truth, but they also created chaos and violence under the guise of religion, and this has become a major global problem, and Malaysia has not been spared from this abuse. Within this context, I would like to define terrorism as the calculated use of unlawful violence or threat of unlawful violence to inculcate fear, intended to coerce or intimidate government or societies in the pursuit of goals that are generally political, religious, or ideological. So extremism and terrorism can be caused by many factors. It can be political, it can be religious, or it can be ideological. So what we're going to focus here is religious extremism and terrorism relating to religion. In Malaysia, initially religious extremism originated from deviant teachings, whereby religion was used as a means to propagate mistrust among the populace and to undermine the democratically elected government. This was a result of misinterpretation of the Islamic faith according to the ideologies of some interest groups. Islam is the religion, not the cause of terrorism. Islam is a religion of peace. However, through the centuries, deviations from the two teachings of Islam take place. And so Muslims kill, despite the injunction of the religion against killing, especially of innocent people. Extremism stems from those who are with an uncompromising mindset with regard to their belief and convictions, which pose as a threat to the nation. If efforts are not taken to win these groups of extremism, they would degenerate into terrorists and strike blindly without regard for the life of the innocent and disrupt the peace and stability of the country. So as you can see here, there have been many occurrences of religious extremism in Malaysia. For instance, in 1977, individual claiming to be Imam Mahdi had attacked and injured an imam at the mosque. Another incident, serious act of violence had been committed on Thursday, September 1980, when a group of heretical followers of another person claiming to Imam Mahdi attacked a police station. A confrontation involving armed military personnel and citizens during the Bomali tragedy of November 1985 and the Al-Maunah incident in July 2000 involved fatalities on both sides, the government and the terrorists. These are examples of armed violence that were driven by the deviant teaching and radical group with terrorist ideology. So as you can see here, up until today, at least 22 local militant groups had been identified by the authority, which relate to those who claim they are the true followers of Islam. Religious extremism and terrorism are becoming ever increasingly worrying and more difficult to contain because terrorist movements have gone beyond national boundaries. They are highly organized, well-financed, and more sophisticated and advanced in terms of communication, strategy, and weaponry. As admitted by the former Deputy Prime Minister of Malaysia in 2016, who at that time was also Minister of Home Affairs and Security, since 2013, the Islamic State, IS militancy, or Daesh also being called, has become the fastest growing threat to Malaysia. The group is extremely dangerous because it espouses the views and teachings that promotes the Takfiri ideology. As you can see from the slide, there are many groups which are terrorist-based or related to terrorist activities, and not only IS, but many other militant groups. And there are also regional militant groups which have connection to neighboring countries, Singapore, Philippines, and also Indonesia. So now the terrorist group are becoming much organized, and they have international accomplice. Okay, so now I refer earlier about the danger of Takfiri ideology. What is Takfiri ideology? Takfiri ideology is characterized by harsh literalist interpretation of Islam, which pronounce apostasy and disbelief against Muslims who espouse differing interpretation on religious matters, thus justifying the interpretation justifying the shedding of their blood. So those who have different view from them, they say that these people can be killed. The ideology legitimized the murder of Muslims and other religious groups who opposed them. The jihadist Salafist Wahhabism led to the formation of numerous local religious extremist cells. These extremist groups shared a common goal, namely to topple down the government, and demanded the creation of an administrative body that would be fully aligned with their own version of Islam. And their goal is in consonance with various statements, which ask the Muslim not to involve the democratic process, but to take arms to topple the government. The war against terrorism must not jeopardize the legitimate rights of the people. The judiciary has to carry out its obligation to protect the people and at the same time guarantee freedom and dispense justice. It is the constitutional duty of Islamic religious authorities to preserve the religion and to safeguard Muslim and insulate the teaching of Islam. So here we have quite a difficult obligation and duty. The court have to protect freedom of religion, and at the same time, the court have to ensure that the freedom of religion is not abused. And of course, at the same time, have to ensure that the right of the public to live peace in harmony. Under the federal constitutional framework of Malaysia, civil court and federal government do not deal with religious matter because it comes under jurisdiction of Sharia laws. And the court of individual state. However, to combat religious extremism and terrorism under the pretext of Islam, the demarcation of constitutional power and jurisdiction in the federal state government is obscured. So the government, which has exclusive power over criminal matters, public order and security, must collaborate with Islamic religious authorities of the state in encountering threat coming from religious extremists and terrorist groups. Now, in Malaysia, as I shall show shortly, that Malaysia is a federal country. Security, public order is under federal government, but Islamic religious matter under state government. So here we need to have a cooperation between federal government and state government, between the enforcement agency and Islamic religious authority in facing the threat of religious extremism. Okay, the religious setting, as you can see under the constitution, there is a provision which protects freedom of religion. However, freedom of religion is not absolute. It can be limited. The case Jamaluddin Osman, as I mentioned in my paper, is about how the detention of a person who propagating Christianity was declared to be unconstitutional and illegal, because the court said that you cannot use Internal Security Act, which is a preventive detention law, to detain a person who exercised his religious right legitimately. So here we can see how the court has protected the right of a person relating to religion and upheld the right when it being limited by law relating to public order and security. Now, you know that the religion actually is to fulfill our spiritual needs. And basically it creates peace between man and man, between man and God, and of course between man and his on the surroundings, the nature. So that is why religious right also has limitation. And this is clearly stated in Article 11, Clause 5, where the court says that there are some laws that can be used to restrict freedom of religion, such as public order, public health, and morality. Okay, and then of course, this is the law which shows that how the court say that only rights relating to religion, which is regarded as fundamental, is protected under the provision. So those which are regarded as sunnah or mandub or harus are not protected and can be limited by the law. Now, in relation to Islamic religious authorities, basically it comes under the jurisdiction of the state government, and basically how the religious authority involved in protecting the public order and security, in limiting the terrorism through the use, for instance, of tawliyah and fatwa. So this is the what we call ideological offenses, a soft approach, whereby the tauliah make sure that only those who have the correct knowledge can teach Islamic religious teaching, and fatwa declares what groups which are acceptable and what group are terrorist groups, for instance. And there are many cases, if you see in the Malaysia, where the court had decided in relation to those who involved in terrorist activities, and the court basically said freedom to profess and practice religion should not be turned a license to commit unlawful acts or to use something which prejudice the freedom and of others. And many laws has been used by the government to control religious extremism, as we can see there. There are some laws regarding a special law and some law ordinary law. Okay, and then these are cases which where the court has held that the offences are terrorist offences, so they cannot rely on religious right to commit terrorism. And finally, I would like to conclude by referring to this, whereby the use of military capabilities, enforcement of the law, and prosecution in court can cause physical damage to terrorist organizations and stifle their activities. However, the ideology underpinning the terror would remain intact. The radicalization measure and countering preventing violent extremism, which aim at tackling ideological roots of terrorism, are considered highly effective in dealing with ideological problem. And then, in relation to limiting the rights, the court have to be very careful, so as when using the security law, not to limit the legitimate right of freedom of religion. And finally, the agency have to step up in order to counter religious activities. I think I stop there because I think the time has come. Thank you very much. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Dr. Has Azman Mukhtar. A very insightful presentations about the how to co-examine the role of the core Islamic religious authorities in fighting religious extremism and terrorism in Malaysia. Okay, I will invite the respondent to respond to your presentations. The respondent is Anna Triningsi, the researcher of the Indonesian Constitutional Court. You have time 5 minutes to respond, and the floor is yours.
Okay. Thank you, moderator. I was given the opportunity to respond to this paper. Hello, Mr. Mukhtar. Thank you for your presentation. I'm very interested in your paper, especially regarding terrorism in Indonesia, in Malaysia. We all know that terrorism is no longer of domestic threat, but has become an international threat that threatens the domestic security of every country in the world. In 2014, international community was again faced an act of the terrorism, namely is the emergence of a new terrorism movement, namely ISIS. In your paper, you have explained a lot about the Malaysian government effort in fighting terrorism. At this time, we all want to know, and for me especially, about your opinion, the effectiveness of the Malaysian government policies in fighting in terrorism. And I want to know your opinion about again ISIS, and how about Khilafah Islamiyah. Thank you.
Yeah. Thank you very much, Ms. Anna Triningsi, for very good comment and very insightful question, which is very important. I just attended a meeting with the multimedia communication provider, basically because a lot of materials relating to terrorism can spread through the internet, through telephone network and those things. So here, basically the ideology, usually people are not violent, But once they have been indoctrinated with this takfiri ideology, they slowly become violent. So the challenge is first we need to stop physically the organization, but at the same time we have to control the propagation of takfiri ideology, this extremist view which being spread out freely through the internet especially. And this is very challenging because those who in charge of the multimedia, like the network provider, the telephone networking, they basically know the technical aspect, but the content, the substance, this is where they say that the release authority have to help them. They have to collaborate. So there is a need to collaboration between the content provider, the network provider, and the Islamic Religious Authority. And another thing is, we at the same time we need to be careful because we do not want to limit freedom of religion, because we encourage people to talk about religion, to spread teachings. But there are a lot of people who spread wrongful teaching. So this is where the role of Islamic Religious Authority become important. Because in Malaysia, I think it is a good point, because when people have issue or problem, they can refer to the mufti, which is appointed by the government. They can refer to the fatwa made by the mufti appointed by the ruler. So they know what is correct and what is wrong. So here I think this is one advantage of Malaysia, because we have the head of religion of Islam, the Sultan, and the mufti appointed by the government. So they basically moderate the views and stop the radicalization and extremist thinking, so that people know what is the correct teaching and what is the wrong teaching. But as of course I admit, as you mentioned, that the threat is becoming global and becoming more difficult. So the authority and the Islamic ideology have to set up a step up their effort, because it also involves freedom of speech, not only freedom of religion, freedom of speech and expression. So this is where we need to be careful, because we do not want to limit legitimate exercise of right, but at the same time you want to ensure to protect the public from this extremist ideology. I hope I respond to your question.
Okay, thank you, Dr. Azmin Mukhtar, and also thank you to respondent Anna Treningsi. Very enlightening explanations, response from the speaker, and thank you for presentations. And we will continue to the second speaker. I invite Mrs. Shakli Satyaratiwi, and I will introduce Mrs. Shakli Satyaratiwi, from the Institute of Human Rights and Peace Studies, Mahidol University, Thailand. And she's a candidate, PhD candidate of Institute of Human Rights and Peace Studies in Mahidol University, and a senior lecturer of Faculty of Law, University of Muhammadiyah Malang, and researcher of Law and of Human Rights. Today, the paper under the title Rethinking the Constitutionally Flawed Indonesia's Anti-Blasphemy Law. I have 15 minutes to present, and the floor is yours.
Would you please the committee to share my screen?
Okay, will committee will assist the. Okay, thank you.
Okay, thank you.
You're welcome.
Yeah. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Thank you to the ICC's committee for arranging this great important symposium, and to moderator for the excellent introduction, and the excellency of the judge of the Constitutional Court of Indonesia Republic, honorable speakers, and distinguished participants. This is an honor for me to have the opportunity to share my thoughts with the title Rethinking the Constitutionality of Flawed Indonesia's anti-blasphemy law. So would you please go to the next? As we all know, the adoption of international human rights law at national level, that embedded in the 1945 Constitution of Indonesia, is not just a formality to show that Indonesia is a virtuous nation. It must be interpreted as a part of the state effort to fulfill the goals of the state, to protect the human dignity of the entire nation, and to promote general welfare. Importantly, it intends to avoid the arbitrariness of the state to criminalize their citizens for manifesting their human right. The protection of religious freedom guaranteed in the various articles of the Constitution are to ensure that a person free to seek, embrace, change, manifest their own choice of religion or belief without facing any restriction, either in public or in private sphere. If those who are blasphemed because their choice of religions or belief are considered heretical, experience several punishment or expulsion, violence, lost their jobs, homes, places of worship, or cause deep trauma to their children, how do such society will achieve prosperity? So if the religious freedom is degraded, the other rights of the people will be violated. It is no doubt that the restriction on the right to religious expression is permissible, but the restriction is necessary if only to protect a person from being targeted by hate or violence without any intent to discriminate against other people. Allowing the presence of repressive discriminatory law is a real threat of human dignity. So actually, there are various studies indicate that the existence of the anti-blasphemy law in Indonesia violates the right to religious freedom, since its provisions are multi-interpretation and discriminate only targeted to minority groups of religions. Using a doctrinal legal study, this study aims to examine how do the Constitutional Court of Indonesia Republic, through various decisions, namely decision number 140 2009 and number 84 2012, number 76 2018, insists to maintain the constitutionality of the law, while at the same time declaring that the law needs to be revised. And to what extent the decisions could degrade the constitutional rights and human rights of the Indonesian people. So next, please. First of all, citing from the various decisions of the court, I found there are at least 4 arguments for the court declaring the constitutionality of the law. First, the court argued that limiting religious expression is legitimate and permissible under the international human rights law, and it's in line with Article 20J of the Constitution. And the second, the limitation is necessary to maintain tolerance and protect the rights of others. And the court also believes that if the law is repealed, it may create a vacuum of law and would be dangerous to the society because it triggers a vigilante or main hakim sendiri. And the court argued that if the law did not apply the right direction by the law officers or policymakers, it is not a matter of the legal substance, but the lack of the law enforcement. So I will elaborate this with some argument. First, in the study, I start with examining whether limitation of religious expression based on or under Indonesia anti-blasphemy law is legitimate, necessary, proportional, and non-discriminative. We all agree that as a protector of human rights and the guardians of the Constitution, the Constitutional Court is indeed required to be able to establish a balance between protecting individual human rights and the rights of the community by allowing the existence of laws that limit a person's right in manifesting his right. But the court needs to ensure that the law should not reduce the essence of fundamental rights and not discriminate against certain groups of religions. So in this Anti-Plus Milo case, as you can see in my screen, the court limit itself to apply only Article 20, only the 1945 Constitution, particularly Article 20J, but put aside the essence of the religious freedom as fundamental rights that strongly protected in Article 28E, 28I, 29, as well as Article 4 and Article 18 of the SSPR that already ratified by Indonesia. So the right of a person to manifest or to express his religious teachings may be subject such limitation if those expression is truly dangerous to the society. For example, encourage people to end their life as part of the religious belief, for example, or to encourage people to incitement of hatred that cause hostility or violence, but not just because they have different religious teachings. No law shall criminalize the person for having or expressing his religion or belief. So, and moreover, in this study, I found that the court did not go deeply examining the limitation standard according to Siracusa principle and General Comment number 22, that limitation must meet 4 tests. First is legitimacy test, necessity test, proportionality test, and non-discriminatory test. For these 4 aspects should be tested subsequently and completely if these 4 aspects do not embedded in the law. So the law is problematic, as consequently should be repealed or amended or considered as unconstitutional. Allowing the application of the fake law will open space to the law enforcement officer to use the law to criminalize a person on behalf of maintaining public order. This law violates constitutional rights that currently in Article 28G of the Constitution, that the right of the people not to be treated arbitrarily. And the weakness of the law enforcement actually cannot be separated from the defect of the legal norms. Next slide, please. Moreover, in this study, I found that the court interpreted the restriction necessary to protect public order or maintain tolerance in a broader sense. By declaring the constitutionality of the law, the court is allowing the extended limitation of religious expression that aims to protect the feeling of religions as regulated in Article 1 of the Anti-Blasphemy Law. So this limitation ground was not enumerated actually in Article 28J and has no clear interpretation. So translating the word public order into religious values to protect the feeling of hostility or feelings of others other to in Indonesia, in many cases defined as the same as hate speech. And this causing a legal confusion, creating legal uncertainty because each word has different meaning and consequences. According to the rapid plan of action, the concept of insulting others people's feeling is lawful act because the word has an abstract and broader concept that is difficult to prove by the court and should not be included as a legal norm. and therefore criminalization of such person is unproportional. If differences in interpreting of religious teaching are resolved through the mechanism of criminal law, when this close the room of interfaith dialogue and other mediation approaches that are more human and more respectful of the fundamental rights of each individual. Furthermore, in this study, I found that the court did not evaluate the limitation test to respect the principle of discrimination. The court did not examine that the phrase religions are there to end Indonesia has been prone to discrimination against other minority groups of religions. As mentioned in explanation of Article 1, the minority groups of religions such as Ahmadiyya, Kafatar, Shia could not freely embrace their choice or belief or religion since they are not recognized and protected by its state. Discriminatory restriction whatsoever is not allowed. Respecting the rights of minority groups' religion without being an example of equal treatment but punishing them for their belief is discriminatory act. The right to be treated equally without discrimination are fundamental human rights that guarantee under Article 27, 28I, 28G, and 20D and 20H. The decision related to anti-blasphemy law is unlike to the legal precedent from previous decisions that made by Constitutional Court before. For example, the decision number 97, 2016, the court overturned a resident law that restricted followers of traditional belief from obtaining resident identity card and family card. In this decision, the court emphasized that restriction in the form of different treatment against someone because of his belief is an act of discrimination. Therefore, the court declared the law was unconstitutional. Overall, I found that the court prioritized the limitation standard based on Article 28G and overrides the position of Article 28E, 28D, 28I, 29, which is repeatedly guarantees the right to freedom of religion as non-derogatable rights and the rights not to be treated discriminatory. They mentioned in Article 27, 28, 20, 28G as well. So next, it is true that the Indonesia anti-blasphemy law is flawed. If we pay attention to the legal norms that have multiple interpretation and excessive restriction that I mentioned earlier, supported by various existing scientific studies on practice of the law in the field, then there is no doubt about considering this law as a flawed law. And moreover, the vagueness of the anti-blasphemy law confirmed by the court, saying that the substance of the law, meaning the Indonesian anti-blasphemy law, in terms of the form of regulation, formulation, and legal principle need to be refined. The court also stated that the need for revision of the law, both within the formal scope of legislation as well as in substance, in order to have material elements that more clarified as not to cause misinterpretation in practice. If the law is flawed, why is it declared constitutional? In my opinion, it violates a person's right to obtain fair legal certainty guaranteed in Article 28D of the Constitution. Next, however, the court believes that repealing the anti-blasphemy law may result a vacuum of law that trigger. Just the last. This argument seems far from the fact in which vigilante acts mostly happen in society following the enforcement of anti-blasphemy law when the law exists, and not the other way around. Repeal the anti-blasphemy law is not necessary cause the vacuum of law, since Indonesia criminal code has been long time effective, would be applied to prevent any kind of violence, including defamation against others. And Therefore, the last declaring a flawed law as a constitutional law actually makes the legislators have no constitutional reason to make any revision of it. Thank you very much.
Thank you, Ms. Shekli Pradewi. A very nice discussion and very fruitful presentation today. Discussing about blasphemy law and constitutional court decision, and also Indonesian constitution is very interesting and expanding our perspective. But today we have our respondent here to respond the presentation today. I invite Mrs. Titis Ananjayati from Indonesian Constitutional Court. You have 5 minutes to respond the article. Time is yours.
Okay, thank you, Mr. Moderator. I found that there are two main things that the presenter would like to explain. First, about the constitutional court decision when declaring the constitutionality of the Indonesian anti-blasphemy law has been influenced by the particular constitutionalism approach instead of the universal constitutional approach. And second, about the court's fear of revoking the law based only on assumption and not support by the fact the Indonesian criminal code is available to criminalize whoever does violence against others. Okay, I would like to respond the first point. According to the universal human rights adherents, human rights are believed to have universal values that are not limited by the space and time. However, in reality, it shows that universal human rights value does not have the same and uniformity in their application. For example, the right to life can be applied differently from one country to another country. The implementation will be closely related to each country's inherent characteristic or unique nature. Moreover, each country has a different economic, political, social, and legal culture system. The Constitution of Indonesia does not provide the possibility of campaigns for freedom to have no religion, and it is not possible to insult or pollute religious teachings that are the source of belief religion or disgrace the name of the God. Religious freedom granted to every human being is not free of values and freedom unsafe, but freedom accompanied by a social responsibility to realize human rights for everyone. Restriction does not always have to be interpreted as discrimination. During the restriction given are as a form of protection against the right of others in the orderly life of society, nation, and state, as Article 28G, paragraph 1 of the Constitution states. It becomes a form of protection of the rights of others at the same time is human obligation or obligation for others. So in here that if you know that in October 2018, the European Court of Human Rights decision was unanimous without concurring opinion that there had been no violation of Article 10, the expression of the European Convention on Human Rights in the case of ES versus Austria Court. The case concerned the application conviction for disparaging religious doctrines. She had made statements suggesting that Muhammad had pedophilic tendencies. The court found in the particular that the domestic court comprehensively assessed the wider context of the applicant's statement and carefully balanced her right to freedom of expression with the right of others to have their religious feelings protected and serve the legitimate aim of preserving religious peace in Austria. The court also considered that the domestic authorities were in better position to evaluate which statements were likely to disturb the religious peace in the country. Some others outlined that with this judgment of the European Court of Human Rights apply different standards to very similar situation rule in the past. For the reason it has been claimed that this judgment de facto endorsed the use of anti-blasphemy laws. From the case that we can learn that even the European countries had realized that there are right for a country to decide that the country has a right to preserve the religious peace in the country. Besides that, Okay, the judge in examining and adjudicating really to determine for themselves the methods. And second, about the court verification the law. If we know the article 300. The article in the Indonesian Criminal Code clearly states to protect one's reputation, but don't forget that this article has shortcoming in the formulation objective about the criminal offense. So in here that I believe that in order to advance democracy and human rights protection in Indonesia, it is important to look at the rights at stake and the development of the society, and to put balance between the rights, development of the society, and the constitutional values of the constitution. That are my response, and I have a question for the presenter. First, how should apply the freedom in the internal forum when it is associated with the public order, because we know that existence of the new religion or teaching sometimes get mass rejection. It is brought to order to maintain public order. And the second, do religious demands to carry out that what fall into the category or internal or external forums? Because on the one hand, there is a duty to spread religion, but on the other hand, it must intersect with the other religion. And the third, that we know even though Islam teaching never force anyone to embrace their religion, in some parts of the Malaysia, there are restrictions on the invitation to convert religion or belief. For example, in the state of Kedah, there is a rule that prohibit someone to live or not to like Islam. So the question is the prohibition for an invitation to convert religion in accordance with the Indonesian Constitution, or those who prohibit religious conversion should be prosecuted for violating constitutional right? And the fourth is from the article, can it be concluded that the changing or modifying religious teaching is a part of the freedom of religion guaranteed by the Constitution? And if so, then the law in its implementation should conflict with the Constitution because it prohibits any changes to religious teaching. Even though changing or modifying certain religious teachings, if it is carried out in accordance with their belief, it includes freedom of religion, which should not be reduced. Thank you.
Thank you just for the responding questions. I give time to Ms. Chakri to respond the questions. Thank you.
Okay. Thank you, Miss. Sorry, I couldn't read the very small letter there. For your insightful comment and also critical question. And I will start with that. I also explained it in my presentation that the role of the Constitutional Court in Indonesia is so much important and vital because the Constitutional Court is the guardians of the Constitution as well as the guardians of human rights. So in this case, I can see that there are a lot of progress that made by Constitutional Court of Republic Indonesia when dealing with the human rights issue. And a lot of cases also that I mentioned in my paper and that I pointed out the case of the traditional belief. They are also protected by the Constitutional Court, meaning that the universal constitutionalism perspective or approach already been done by Constitutional Court, and many landmark decision has been made. But in this case, I see that it's kind of like, setback to the particular universalism in terms of the protecting the minority groups of religions. And related to your point, we know that International Declaration of Human Rights is a common standard of human rights achievement, meaning that common standard means the minimum standard. So every country can modify into the upper standard, but not the lower standard. So this is what we call why there is a variety of the, of the protection of human rights if you can see, particularly in economical, social, and cultural rights, because the economical, social, and cultural right is a positive rights. It's depend on the country situation. But if you're dealing with the civil and political rights, you need to be careful not to degrade the common standard that already stated in the International Human Rights, International Declaration of Human Rights, and in terms of civil and political rights that stated in the ICCPR, Indonesia is ratified without making any reservation. It doesn't mean, it means that there is no such article that rejected by Indonesia. So it means we have the obligation to fully implement what is stated in the ICCPR. And I think our constitution of the 1945 already, adopted all, a provision that stated in the ICCPR as well as in ICSCR. So that's why I think what the court should do is just looking at other article, not just focusing on the limitation standard that mentioned in Article 28G, as I mentioned before. And talking about the right of others is not defined as the feeling of others. This is something different. The right of others mean that you cannot do something or express your religion if the other people cannot do their rights. For example, if you for example, in the case of what happened in Europe, if you promote something hate to other people, and then the people cannot do their right, such as cannot stand their own choice of belief, cannot embrace their belief, cannot practice their religion, then this is what we mean the rights of others being disturbed. Not just, because the ICCPR didn't protect your feeling. Everybody can feel hurt of anything. And those are very subjective, very abstract. How can you prove that your feeling is hurt or not hurt? That's very difficult. But if someone encourages other people to attack other religion, and other religion cannot practice their right, that means you disturb the rights of others because they cannot exercise their rights. But in the case of Indonesia, minority religions, when they believe that, when they believe their religion or their teachings of religion, they're not intends to disturb others because other religion can still do their rights properly without any disturbing at all. So why we should punish them? So this is my question actually. So in this case, I already answered your question about public order, and I think if we want to make this law very clear, then if we don't want to repeal the law, then the revision of the law is a must. Because if you look at the anti-blasphemy law, there is no such clear definition or indicator how to limit the freedom of expression, particularly forum externum. There is no such indicator at all. And what you want to define as public order, what do you want to define as, for example, disturbing the health, public health, for example, or disturbing the interest of national or the morality of others, this should be clearly defined so that no multi-interpretation happen in the society. So, this is to respond your second question, and about the this is actually whether religions modify their teachings or not. This is not the state that have the right or authority to punish the person because of their belief, because every religion have different kind of the religious school. I mean, the teachings of the religions very diverse, and we cannot just simply saying that because of the difference of the teaching, then your right is degraded because other people have different teachings of it. What we can do is respect them, and as long as this not dangerous toward the public and not make other people cannot exercise their rights, then it would be fine. If there is a conflict, if there is because of the lack of understanding of the people, that education is the humanist way to educate people who don't understand, for example, the religion in the right way, for example. So we will choose not the repressive approach, but more interfaith dialogue approach, and kind of thing that's more acceptable for the people. Yes, I think this is my response. Thank you very much.
Thank you, Dr. Pratini. And this is the end of the second speaker. I would like to say thank you for the respondent and also for the speaker. And I would like to invite the participant to ask to use the raise hand. But due to there is no question from the participant, we will continue to the next speaker. The last speaker in this session, I will invite Mrs. Tri Sulistianing Astuti. And I will write this. Ms. Tri Sulistianing Astuti is from the School of Government and Public Policy in Indonesia. Is graduated from the School of Public Policy in Indonesia, selected as participant in Venice Summer School 2021, and today we'll deliver the paper under the title Satire, Expression, and Blasphemy, Finding Its Proportionality in Indonesian Religious Society. You have 15 minutes and the floor is yours.
Thank you so much. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Moderator Bapak Mahrur Ali, speakers, respondent, and the participant. It is an honor for me to be the part of this forum. Previously, Dr. Hairul Azmin Mohtar and Ibu Ceklit Pratiwi has presented their very interesting and insightful issue for me. Thank you so much for that. Before I start my presentation, to be honest, I'm not a law and religion expert, so this rare opportunity provides me a chance to broaden my view on this issue. First of all, I will introduce myself. I'm Tri Sulistianing Astuti from School of Government and Public Policy Indonesia. So today I will present my paper with the title Satire, Expression, and Blasphemy, Finding Its Proportionality in Indonesian Religious Society. Next, please. Slide master. Okay. This is the outline for my presentation today. I will highlight the freedom of speech, freedom of religion, because it intermingling with the satire expression and also the satire itself, and then the proportionality. Next, please. So I have collect some definition of what is satire. So the satire itself is concluded as a form of to critique and entertain, and those two aspects purpose must interact each other. It's also including the humor to respond the particular context of contemporary politics or other topical issues. Some of the country like Germany and also European Convention on Human Rights and the Supreme Court of United States recognize satire as protected speech. So this is a part of freedom of speech. Next, please. However, satire expression create a damage effect in society. One of the famous example is a Charlie Hebdo tragedy in 2005 that affect 12 death victim, including police officer, Charlie Hebdo editors, and several injured people. That is like a satire goes wrong and produce violence and create another issues like discrimination and xenophobic. However, some scholars still argue that this satire expression, the satire cartoon from Charlie Hebdo is part of freedom of speech because in France they defend secularism. But for some Muslim scholar and also for extremists, it's perceived as blasphemy because it includes the Prophet Muhammad drawing picture in those cartoons. How about Indonesia? For Indonesia, the freedom of speech is not absolute, but it can be restricted under the certain circumstances. And the religious content satire would become a sensitive issue for freedom of speech in Indonesia because Indonesia society recognize multi-religion. So how to proportionate these two freedom that include in religious satire? I mean, we can use a proportionality. Next, please. Next, please. Okay, under those introduction, I have a research question here. First, how the freedom of speech and freedom of religion intermingling in satire expression. And the second one is how the government create religious satire limit based on proportionality test for Indonesian religious society. Next, please. Next, please. Okay, so I start my study with compare three norms, which is ICCPR and ECHR, and also our constitution, Indonesian constitution. These three have a same because it ratified the UDHR as a part of the values. And next, please. And that will be effect on the proportionality that we will discuss later. So I will invite you to know what is the contribution of the satire as a freedom of speech. Some scholars say that satire contributes to communication democratization because it's part of freedom of expression. First, it enhances dialectics. And the second, it's satire always involves another subject, an interpreter, so that heterodox concept provoke louder and as a shared expression. It can for another expression that cannot be if people cannot access the official pipeline of communication. And the third one is satire promotes social exchange because people can make their own satire to criticize something or to share their idea. As I said previously, that the U.S. Supreme Court and the HEHR already recognize it as a protected speech, and also the U.S. Supreme Court and the HEHR, European Court of Human Rights, also make a categorize what is become the protected speech and unprotected speech. Next, please. So for Indonesia context, as far as I know, none of the regulation in Indonesia mentions satire as protected speech. And also, there is no exact form of expression to embrace freedom of speech defined by law that have the cross-border with the freedom of religion. The law that established is only prohibit the acts, purposes, and content. It's an article in Criminal Code 156A, and some regulation for expression is like ITA law or Electronic Information and Transaction Law, and also the law against blasphemy. Next, please. Now, in this part, I want to invite you all to see the 3 case studies that I brought in my paper, that each of the case bring the different purposes. So first is the political value of satire. Sometimes satire with the religious symbol inside it it's used for the political purposes. The case is like a Geert Wilders satire to raise popularity to his party, which ended second in official result. However, this is political satire is offside and goes wrong, although the purpose of satirist is achieved. It's create discrimination against the Moroccans because they are a Muslim community in Netherlands. And also for the moral function of the satire, it's remain offset because it doesn't have any contribution to the political system in Netherlands. And the second one is satire to defend the beliefs. In this case, I again use a Charlie Hebdo example cartoons to defend the secularism. However, it offside because some perceive it as a blasphemy and create violence. And because of the development of digital media, it can be assessed not only in France, but all over the world. So the discussion become the broader spectrum and create like another issue, discrimination and xenophobic. And the last one, next please, a case in Indonesia in Dr. Otto Rajasa Satire, that he post something, comment on Facebook that already deleted, and he charged under the ITA law, even though the Islamic Defender or FPI submit him to the police, reported him because of insulting Islam. Dr. Otto is as a Muslim. His satire is from of his disapproval of the blasphemy case that befell Ahok or Basuki Cahayapurnama in 2017. Next, please. So from the effect of satire that offside goes wrong, I try to analyze the three norms under the three-part justification of ECHR. It's a test of legality, necessity, and proportionality. Previously, Bu Cekli Pratiwi has explained it very well, and thank you for that. It broaden my view and give a framework for this discussion also. Next, please. And I use this European Court of Human Rights conception under the ECHR to make a consideration of limiting freedom of speech in regarding to freedom of religion also. The court giving 5 considerations to assessing freedom of expression, including satire. His is first, the aim of pursuit by the speaker or author. And the next one is the context of dissemination and the potential impact. The third is status and the role in the society. It's like the court said that people that have more role in society and popularity have different assessment with the ordinary people. And the next one is target of statement. Is it including minority or discrimination people? And the last one is seriousness of interference. In some of the case that are decided by the court, it also highlight the duties and responsibility term in Article 10, paragraph 2, that the expression have to avoid gratuitously offensive in the context of religion, opinion, and beliefs. And the one that interested is criticism is allowed. And people who exercise their right to manifest their religion freely cannot expect to be exempt for criticism. Next, please. Okay, and how to bordering religious satire to blasphemy for religious society in Indonesia. As we know that, and I analyze, please at me if I still use a misreference. First is article in Criminal Code 156, and the second one is law anti-blasphemy to prohibit deviant interpretation of religious teaching, and the last one is ITA law to cover disseminating online content deemed blasphemous. As we said previously, that the main difference proportionality of freedom, religion, and freedom of speech in Indonesia and ICCPR and ECHR is the values of religion. Bu Cekli Pratiwi already highlight also the religious values for the legitimate aims in the Indonesian Constitution. And also the law against blasphemy broaden the blasphemy definition to prohibit deviant interpretation of religious teaching. Despite this, law against blasphemy has already submitted to judicial review 2-3 times, but it still have a many different response from the people. Next, please. Okay. So this is, I just may show you the interpretation from the decision of the court number 114 in 2009 regarding the anti-blasphemy law. It highlights the discussion of the interpretation of believing and practicing the teaching of religion under the scientific authority of religious leader or representative religious community, and also the discussion of the external forum that subject to restriction. And also the discussion is hit because of there is a dissenting opinion from the Judge Maria to emphasize the official and unofficial religion stated in implementation of the law of blasphemy that would be create a discrimination. Next, please. Next, please. Would you please next? Okay. So how religious satire going with that situation in Indonesia? So refers to the court argumentation, Indonesian Constitutional Court argumentation, only the authorized person can be satirist because production satire will include interpretation of the religious value as a ritual. Can people individually use satire to criticize religious practice if it has dropped others' parties? So it also creates a challenge here because there is an issue on majority versus minority interpretation on blasphemy and hatred and hostility. Also, it raises question, no clear boundaries on the definition of telling the public. Is it posting on media social that already set up for private consumption? It's a public tool. And also the rise of concern in subjectivity interpretation of diverse self-interpretation of religious value. In the context of Rajasa, it includes the political condition, context, and political powers on that situation. Next, please. Next, please. Okay. So after the study, I come up with the conclusion. First, it's the restriction of freedom of religion and freedom of speech in Indonesia, proportionate the religious value as one of the legitimate aim. Satire can be restricted when it comes to blasphemy, and also considering content and purpose of satire, the role of author, political contact with the respect of ethnic, race, and other sensitive issues among religious society in Indonesia. And aside from the critic and moral function in satire, we have to realize that political purpose, power may intervene to be the context of satire. Sorry, Pak Mahrus Ali, can I have 2 minutes additional time to conclude my presentation?
It's a minute.
Okay. And then Indonesia can follow example of the HEHR in categorizing protected speech and unprotected speech. And it is necessary to reformulate a more detailed definition and explanation about prohibit content, solely using the term cause hatred and hostility based on SARA or respect for ethnic, race, and other sensitive issues among Indonesia, as mentioned in ITE law and criminal code. And the last conclusion is the relative interpretation of blasphemy become the challenge for the court decision to perform the proportionality test. Therefore, the judges should have expertise to broad issue on human rights, power relation, political power, and society law content, religious values, as Dr. Checkley previously mentioned. For each religious community are the key to decide whether religious satire vis-a-vis blasphemy or critic moral under the proportionality test in article in Constitution of Indonesia. And also it needs the interpretation also from the legislator because they make the policy. So the broader knowledge also have to include the legislator perception on human rights. The last one is my recommendation from this paper. Next, please. So I suggest that satire expression should be recognized as form of freedom of speech in Indonesia. And the second one is the limitation of satire has to be defined in law regulation to avoid the misconception of religious satire blasphemy in judiciary decision. This part is the important role of the legislator. So we have to pay more attention on the legislator process. And the last one is the there are 3 laws related to religious satire that must be revised. It's Article 156A KUHP, Criminal Code, Law Anti-Blasphemy, and Law ITA 2008. In addition, it needs provide more detailed definition, explanation, and forum extreme expression for embracing religion and classification protected speech, unprotected speech to guarantee and protect individual communities' right to freedom of speech in democratic state. That's all from me. I can wait to listen the comment and respond from the respondent. I give it back to you, Pak Mahrus Ali. The screen is yours, please.
Thank you, Ms. Astuti, and it's very interesting and presentations regarding the freedom of speech and also satire expressions and also the freedom of religion. Okay, I will invite the respondent from the Indonesian Council for Researcher, Ms. Rizky Sabana Yusuf Savitri, to give the response for the Ms. Astuti presentation. Ms. Sabana, okay.
Thank you. Can you hear my voice clearly, Ms. Astuti and Charlie?
Your voice is clear and you have 5 minutes to respond.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, Ibu Tri. May I call you Ibu Tri? Okay.
Yes, of course.
Okay. Thank you for the time and screen given by the moderator at the committee. Ibu Tri, I would like to congratulate you on the completion of your amazing paper and presentation. Your paper actually is very interesting paper for me personally. I'm sure this paper will provide us a fairly clear picture of how a satire on freedom of expression and speech can be blasphemy against a specific religion, causing problems among religious society. From your paper, we all know that religion is a very sensitive issue in Indonesia, because in my own opinion, having 6 religions recognized according to the law number 1/PNPS/1965 demonstrates the diversity of the Indonesian nation itself. But on the other hand, in order to avoid some schism, it should also foster a high level to tolerance in the society. This tolerance will also have an indirect impact on freedom of expression and religious freedom. Why? Because according to your paper, freedom of expression, speech, and freedom of religion are part of the human rights which are regulated in Universal Declaration of Human Rights, which was later adapted into Article number 18 and number 90 of the International Conference on Civil and Political Rights in 1976. And also regulated in 1945 Indonesian Constitution. Satire expression is one form of free expression that if it's not carefully regulated, can be a problematic. In quoting your paper, when satire goes wrong, it can be crossing the line between freedom of speech to blasphemy. Ibu Tri, I would like to ask you some explanation. What are the limits of something that can be cited to be blasphemy? For example, if is it when an ustad or ustadah is giving a discourse in a mosque and then says that another religion is wrong, another religion is false, and then the followers of the other religion hear it, can that be considered as a blasphemy? Otherwise, can a priest or other religious leader be accused of blasphemy if he disparages another religion in front of his congregation? The second, Ibu Tri, you said that the blasphemy case was submitted in the Constitutional Court for review 3 times, if I'm not mistaken, in in 2009, 2012, and 2017, right? With the Constitutional Court rejecting all the three applications in its decision, and that at the end of the decision number 140/PUU/7/2009, the court agreed to revise the blasphemy law, both in its formal or substantive scope. And the Constitutional Court acknowledged that the blasphemy law needed to be revised in decision number 84 in year 2012 and decision number 56 in 2017. According to your paper recommendation, if I'm not mistaken, this means that you believe this Indonesian blasphemy law should be revised. And I'd like to hear your thoughts on the future possibilities as the blasphemy law is revised. Will it truly make religious society more tolerant? And do you believe there is an appropriate penalty when satire goes wrong and becomes blasphemy? Is it right to impose a criminal penalty? Well, I think that's all of my responses and questions to you, Ibu Tri. I very appreciate your paper, which has broadened my perspective on satire and satire expression and blasphemy. I wish you have a great day for you and stay healthy. Thank you. Assalamualaikum warahmatullahi wabarakatuh. Charlie, I give back the screen and time to you. Thank you.
Here, and I will return to Mrs. Tri to respond to the commentary. Thank you.
Okay, how many minutes do I have to answer the question, Pak Ali?
5 minutes more.
Okay, 5 minutes. So it's gonna be a short answer, actually. Thank you so much, Ibu Kiki, for the response and also for the very difficult question for me, actually. Honestly, we have the same concern about that because there is no such limit in freedom of speech and freedom of religion related to the satire. But in my paper, I propose that we can make what has been done by the European Court of Human Rights to proportionate under their consideration. First is the aim of pursued by the speaker or author in expression contents. In the case of Gerrit Wilder previously, his aim is to raise political popularity, so that it's not critique the moral or something related to religious practice. So it goes wrong. And the second one is the context of dissemination and potential impact. Some scholars propose the self-censorship doctrine, that we have to think before, we have to censor ourselves as the message producer before we disseminate the satires. So it's related to the context and potential impact. And the third one is the status and role in the society. Okay, the people that have role like an academician, like a president, like a politician, or maybe celebrity, that as intentionally they aware that they have a mass people that following them, it will be assessed heavy on the satire expression that create impact to the society. And the next is the target of the statement. Some studies found that the satire expression is mostly attack the minority, and the interpretation of satire is mostly derived or created by the majority. Okay, that's the proportionality that should be considered. And the last is the nature of seriousness of interference and the sensitivity of penalty. This is the court decision domain to assess it. The last one is I also want to address the duties and responsibility as the society that live in democratic countries. We have to realize we are the part of the society that multi-religious. So we have to understand that before we express our satire, that gratuitously offensive or serampangan without thinking, that it will create effect on society. It has to start with ourselves as a message producer. And we have to understand that our religion is not the one that what is the best the good thing meanings. It's only for us, but maybe not for the other religion. So this kind of balancing tolerance, that including, like Bu Chekli Pratiwi said before, that the interfaith discussion, interreligious discussion, that include not just seek the majority religion, but also the belief, traditional belief in Indonesia should help more intensely. And the last one is, it's part of my question to Mbak Kiki, and still get formulated, because some of the content in the judicial review, I agree with that, because I raised a question before that, is it remain a satire if we post our satire expression? Because we know we can criticize to the House of Representatives, to academicians, because we don't have the access to them. So if we just merely post our comment in Facebook that is private, setting private, only our friends can see that, to like create a discussion, because we don't know, or we want to get more information or another view. Is that including the public? I don't know exactly. So that if I have a chance to make a submit the revision to the blasphemy law, I will suggest first is the definition. What is remain the public telling? What is remain the public expression in religious? Is that salat is it a public right? Is that should be regulated, or another religion like a belief, traditional belief, can exercise their belief like a Muslim people exercise the belief in salat Eid, that including mass people in same situation, in one situation. So that's the first one. The third one is, what kind of content of blasphemous here? Is this a hate speech? Is blasphemous? For me, I don't think so. We have to assess one by one why somebody say hate speech is a blasphemous. Because if you are minority, then you have something inside you that cannot get out, or you get a repression from the powerful people, powerful group. So satire is one of the way to share your ideas. I hope that little bit, but not full, answer your question. But if you may have discussion further for me, you can contact me through my email, and I'm waiting for your other response to broaden my view and in related to the religious and expression policy to Indonesia religious society for the future. Thank you so much, Pak Mahrul Ali. Thank you so much, Bu Kiki. The time is yours, please.
Very interesting response from Ms. Trisni Astuti, and maybe we will continue to the next session. Thank you for all the speakers and respondents and all participants. Due to there is no questions from the participants, we will continue to the next session. And big applause for all speakers. And this is the end of our session. Thank you. I return to Master of Ceremony.
Thank you very much, Mr. Mahrul Ali. Ladies and gentlemen, we are now going to start the last sessions of today's discussion. It was a very exciting conversation and discussions. So for the next sessions, I invite Dr. Irfan Nur Rahman to moderate the last sessions of today's symposium. I give the time and screen to Dr. Irfan Nur Rahman.
the 4th Indonesian Constitutional Court International Symposium, ICCIS. Following the success of our previous international symposia in Surakarta in 2017, Yogyakarta in 2018, and Bali in 2019, the Constitutional Court of the Republic of Indonesia will hold the 4th Indonesian Constitutional Court International Symposium. The Constitutional Court of Indonesia provides an international academic forum to discuss various constitutional issues in comparative perspectives, with the theme Constitutional Court, Religion, and Constitutional Rights Protection. The Constitutional Court of Indonesia gives opportunities to legal scholars, researchers, lawyers, and practitioners to participate in the Indonesian Constitutional Court International Symposium. For further information, please visit www.iccis.mkri.id.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen, distinguished speakers, respondents, and participants. I hope you are doing well today. My name is Irfan Rahman. I am a researcher of the Constitutional Court. In the last session, there are two speakers which will be presenting the paper. First of all, I would invite first speaker, Professor Ni'matul Huda. Assalamualaikum, Prof.
Waalaikumsalam warahmatullahi
And we'll be
wabarakatuh.
joined with Professor Ni'matul Huda, Mr. Muzain Ahyar. Assalamualaikum, Mr. Muzain.
Waalaikumsalam warahmatullahi.
And the second speaker, I would invite Mr. Zainal Mutakin. Assalamualaikum, Mr. Zainal Mutakin.
Waalaikumsalam warahmatullahi wabarakatuh. Good morning, everybody.
Okay. Professor Ni'matul Huda and also Mr. Muzain Ahyar will present together. And for the first presentation, maybe will be presented by Mr. Muzain Ahyar. So I will be tell the brief curriculum vitae. Professor Ni'matul Huda, professor from Islamic University of Indonesia. Professor Ni'matul Huda is productive writer, so many books has already published by her, and I always read her books. And I really enjoy when I read every book that's published by Professor Ni'matul Huda. And also Mr. Muzain Ahyar, a lecturer from UIN Sultan Haji Muhammad Idris Samarinda, Indonesia, which already published many articles of journal. And the topic that will be presented by the first speaker is Islamic constitutionalism, Islamic social movement, and the framework of Indonesia Constitution. So I would invite Mr. Muzain Ahyar for the first time to present the paper. Thank you.
Okay, thank you, Mr. Moderator. Is my sound clearly now?
Yeah. Okay.
Okay. Thank you. Honorable judges, dear speakers, moderator, Dr. Irfan Hakim, and all participants of the 4th Indonesian Constitutional Court International Symposium. It is an honor for me having this forum because this is an excellent opportunity from Mahkamah Konstitusi. I also feel great today because I become a part of this discussion between two my lectures when I took my graduate and postgraduate program both in Surakarta, IAIN Surakarta at the time, and UIN Yogyakarta. Pak Zen, PhD, how are you? And Prof. Nikmah. I feel great, really. Okay, before starting my presentation, this theme of article is actually inspired by our discussion, Prof. Nikmah and I, several years ago, responding to the numerous and voluminous Islamic movement, namely Aksi Bela Islam. The activism took several cases like Ahok, the religious blasphemy, and general election in 2019. We know that the movement is looked to challenge state authority in the view that the ruling government is not Islamic or far from Muslim interests. In this condition, Islamic constitutionalism is felt. First of all, let me begin this presentation by stating that Indonesia is a plural country with various identities, social, religions, ethnics, political ideologies, and so forth. This plural condition sometimes leads to the heavy debate on determining Indonesia, whether Indonesia is an Islamic or non-Islamic country, Islamic or non-Islamic state. Well, the debate on this issue can be traced back since pre-independence era, especially in the Risalah BPU PKI, the minutes of investigating agency of preparatory work for Indonesian independence. We know that the discussion addressed to discuss the ideology of the state. There are three factions who were delivered their argument sharply at that time. The first, the faction from Sukarno and Supomo, Prof. Supomo. The second faction, Muhammad Hatta and M. Yamin. And the third, Kahar Muzakir and Ki Bagus Adikusumo. Those three factions reflecting three living ideologies at the time: socialism, communism, nationalist democracy, and nationalist religious or religious nationalism. This debate finally is finished by determining Pancasila as the state ideology, neither Islamic nor non-Islamic country. And this is how Islamic constitutionalism take place with other constitutionalism in the first era of Indonesia. Then, after the independence of Indonesia, the sound of debate regarding Islamic constitutionalism re-emerged in the early years after independence era, when the unfinished debate occurred in the Assembly of Constituent, what we say in Indonesia, Majelis Konstituante, in discussing a new formula of Indonesian constitution. It means that constitutionalism of some Indonesian people is occupied by Islamic value that they believe, especially for Muslim people. It is in line with the definition of constitutionalism itself, which is the doctrine that government's authority is determined by a body of laws, and state power should be limited by certain values. In Indonesian case, of course, some Muslim people believe that a government should be controlled by Islamic norms. In early years after the independence also, moreover, some Muslim people organized power in rebel movement, which were declared the Islamic State of Indonesia. We know DITII, Tentara Islam Indonesia, Indonesian Islamic Army. In this case, they even transformed a discourse of Islamic constitutionalism into a real movement. Those phenomena reflect the kind of surrounding Islamic constitutionalism in the pre-independence era and the early years after independence era. Nevertheless, the debate seemed to be presented again and again in the post-democratization era in the 1988 after the collapse of the President Suharto. Moreover, the debate on Islamic constitutionalism in several times, accompanied by mass rally through several social movements. In other words, there is unfinished debate on this issue among Muslim people in Indonesia. And they use social movement to promote that Indonesia should be ruled by Sharia norms, or at least stand in Islamic constitutionalism. Several phenomena, I think, in Reformation era, in era Reformasi, confirm this unfinished debate, such as the exhortation to set back to Piagam Jakarta Charter, which has an implicit redaction on the Sharia law, and also the flourishing in Islamic Party, some terror actions, and lately, this is the interesting topic, there is a discourse of NKRI bersyariah, Indonesia with Islamic law. The discourse of NKRI bersyariah emerged in the middle of mass rallying, aksi bela Islam 212, reuni 212, persaudaraan alumni 212, presidium alumni 212, or whatever they call. The discourse sound like an allurement to Indonesian people to implement Sharia constitutionally. Just like this, we have to implement Sharia because we are Muslim, but we don't have to rebel the legal government to gain this aspiration. We just need to get this idea with constitutional effort. One of the effort is to amplify the spirit of Islamic constitutionalism. Okay, so from the introduction, the question that we are dealing here with our presentation with Professor Nikmatul Huda is regarding the dynamics interplay among constitutionalism, Islam, and social movement. How do the spirit of constitutionalism and Islam play a role in strengthening Indonesian constitution? What kind of pattern do Muslim promote Islamic constitutionalism? Okay, to make it short, yeah, I will jump to the this slide. As the result, there are several additional words agama. The voice of Islamic constitutionalism is massively amplified during the Reformation era. Yeah? As the result of this voice of Islamic constitutionalism, there are several additional words agama, religion, in the Constitution. There are 2 words agama written in the Constitution from formerly only 3 words of agama. 2 of the words agama are related to the sumpah jabatan, out of office. 2 words agama related to the function of the Regional Representative Council, DPD, which participate in overseeing the implementation of laws relating to, one of them relating to religion. 1 word agama related to judicial power within religious courts, 1 religion other related to effort in promoting and developing education and culture, and the rest, this is the most written word agama in Constitution, are written in the Article 28A to J and Article 29 of the Constitution related to human rights. Well, the inclusion of the word agama in the Constitution shows the state's attention to the existing religion in Indonesia. In other words, the constitutionalism of the Indonesian people is brought, one of them by religious enthusiasm. Then, what changes occur? Now, what changes occur with the addition of religious content in the Constitution? At least there are 2 national changes. The first, legal changes and legal adjustments, and the second, national changes in social conditions, education, culture, and economic infrastructure. Okay, as an explanation, a decade after the amendment to the Constitution, many religious voices began to appear, which were formalized in statutory regulation. At the statutory level, the level undang-undang, there are 8 laws that contain Islamic law in the field of economy and justice and also halal product. Some of these laws are, for example, concerning law number 10 concerning banking in 1999 concerning management of zakat, in 2004 concerning wakaf, in 2006 concerning religious courts, which is the alteration to law number 7 1989, and also in 2008 concerning SBSN sukuk, what we say in English, Islamic bond, Islamic debenture, or something like that. In 2008, concerning Sharia banking, law number 23 of 2011 concerning zakat management, law number 33, this is the last, in 2014 concerning halal product guarantees. Now, with the existence of this law, with the nuances of Islamic law, there are dozens of derivative regulation that technically regulate the implementation of the law. This proves that the government is actively and massively making legal adjustment stemming from the spirit of Islamic constitutionalism of the Indonesian people. So we jump to the conclusion. To summing up, what really goes on a narrative of Islamic constitutionalism and its relation to social movement in Indonesia? At least there are 2 important points can be highlighted here as the answer and summary of this article. The first point, the voice of Islamic constitutionalism is always accompanied by social movement. This social movement is increasingly able to mobilize more people in the era of democracy. Moreover, in line with the wave of nowadays political populism, social movement is always side by side with the narrative of Islamic constitutionalism. And the second point is the narrative of Islamic constitutionalism is sharply directed to Islamize the constitution as an interpretative effort in socializing Islamic and national values. On another side, the amplification of Islamic constitutionalism is achieved through formalizing Islam. There are two patterns in socializing Islamic constitutionalism in Indonesia. First, Islamizing the constitution, and the second, constitutionalizing Islam. I realize that this constitutionalizing is not official term of English, but I mean by constitutionalizing is formalizing Islam to be written in the constitution. Okay, this is our presentation, and maybe Prof. Nimatul Huda will complement this presentation shortly. May I check the time to Prof. Nimatul Huda?
I'm sorry, Professor Nimatul Huda. We only have 2 minutes later because this is a tricky time in this last session. We have finished this session before 12:20. We have to finish this session. So I hope you can give a briefly presentation. Thank you.
Ya, boleh. Makasih. Nanti saya ikut menjawab saja.
Okay. I think it's very interesting discussion related to the Islamic constitutionalism and how it's derived to the law under the Constitution. So in this session, I would invite my colleague from the Constitutional Court, Mrs. Mary Christian Putri, to give a response. Okay, are you ready, Mary? Okay, the time is yours. 10 minutes from now.
Good afternoon. Can my voice be heard clearly, Mr.
Okay.
Moderator? Thank you very much.
Okay, time is yours, Mary.
First of all, I'd like to say it's very nice to meet you again, Prof. Nikma. It's an honor to me to give an opportunity to give response or comment of your co-paper with Mr. Mujahir. Yeah. Well, Mr. Nikmatul Huda is my lecturer when I took my postgraduate or master degree at the Islamic University of Indonesia. Firstly, I would like to highly appreciate your co-paper, which is a very systematic, tailored, especially in the description or in how this paper describing the development of social movement that contains Islamic constitutionalism, which actually this Islamic constitutionalism can be found and seen in some or in the development of political parties in the Indonesian democracy systems, and then in the how the Islamic values can influence the formations of Indonesian constitutions. It is very clearly described in the paper, especially in the from a history approach. Yeah. But then, what I can conclude from your paper and hear from your presentations today, I assume that you suggest a theoretical approach of the Indonesian constitutional framework, which could be developed based on or influenced by the Islamic constitutionalism itself, right? But then we have to understand it has become a common sense, right? In our beloved country, Indonesia, most of the time, social movement usually happens due to a post-truth that is amplified repeatedly. So there is a post-truth, then it is repeatedly amplified by the social media or mass media amplifications, and then it leads to a social movement. Then the social movement itself address a national or government policy which seems or tends to accommodate the interests of the protester, of course, or the people, the society who do the social movement. Now, from your paper, then it leads me to raise some questions, even though it doesn't have to be all answered at time, yeah, due to our very strict time. There are actually three questions that I would like to address in this opportunity. First, well, in your opinion, how do you think it's necessary to formalize the Islamic values in the constitutions? Because, our first 5 principles or sila pertama Pancasila, we have 5 principles stated that believe in the one and only one God. Well, belief in the one and only one God here is not defined as belief in Muslim, right? Yeah. Well, we at least have 6 recognized and regulated religions, and the state and the constitutional court by their verdicts also give specific protections to even non-believers. So how is it in your mind about your idea to formalize the Islamic values in the constitutions, not only in the states but also in the constitutions? And then the second, well, as one of the editorial team of Constitutional Review, I not only see and read and find the substance of your paper, but also the format and the in Bahasa we call it gaya selingkung, ya. In your abstract, you mentioned some states like India, Thailand, Vatican, and then Arabic, Iran as states whose constitution were based on religious values of the majority citizens. Probably I can assume Iran and Pakistan's constitutions were based on Islamic values, and then Vatican is a state whose constitution is based on Catholic values. my question is, I don't find any explanations at all, or even further descriptions in your body of paper. So it makes me question why you should mention them in your abstract.
Okay.
I mean, is it really necessary to mention them like that? Then the last questions, do you really suggest that Islamic constitutionalism should have affected the government plans and idea to amend the 1945 constitutions? You know, lately, at least in the last 2 or 4 weeks on the televisions and the mass media, we have heard that the government or the legislators have planned to do the 1945 constitution amendment. Then even though never mention or they never talk about how Islamic constitutionalism should influence the amendment of 1945 constitutions, according to your paper. Well, if it said so, do you suggest Islamic constitutionalism will influence the or will be adopted in the amendment of 1945 constitutions? That's all for me. Thank you very much for the opportunity. I am looking forward to hearing your explanations further. Thank you.
Thank you, Mary. And I return to Professor Niamatul Huda.
Ya.
Please.
Mohon izin saya menggunakan bahasa Indonesia untuk
Ya, Prof.
menjawab Mbak Mary. Terima kasih atas responnya. Pertanyaan yang bagus sekali. Di Pancasila sila pertama itu sudah ada ketuhanan yang Maha Esa, gitu ya. Bagaimana kita akan mengelaborasi. Meskipun Islam itu mayoritas di Indonesia, tetapi pembahasan sejak hari kemarin hingga hari ini kita selalu menggunakan Pancasila itu sebagai parameternya, bahwa ketuhanan itu tidak hanya miliknya Islam, gitu. Tetapi ada banyak agama yang kemudian diakomodir oleh Indonesia dengan payung sila pertama di Pancasila. Tadi sudah disampaikan oleh Mas Muzazin bahwa gerakan Islam yang katakanlah Islam yang garis keras, yang menuntut supaya berubahnya menjadi negara Islam itu juga ada ya. Tetapi sejarah membuktikan bahwa tidak pernah sampai pada titik kompromi bahwa kita menjadi negara Islam. Jadi sila pertama Pancasila itu menurut saya sudah cukup bagus memayungi semua agama yang ada di Indonesia. Jadi itu tidak hanya dominasi miliknya dari umat Islam. Apalagi di pasal 29 ya, kebebasan untuk beragama itu juga tidak di situ tidak disebutkan secara eksplisit harus Islam. Artinya berarti kita yang harus dilakukan apa? Di situ adalah istilahnya ya dulu itu toleransi antar umat beragama itu menjadi kunci gitu. Jadi tidak harus mendiktekan mayoritas pada minoritas, juga tidak harus mengunggulkan minoritas untuk menekan yang mayoritas, tidak gitu. Kita ini ada titik keseimbangan ya di dalam bernegara, sehingga itu yang harus dipertemukan, tidak harus dihadapkan. Yang berikutnya, kenapa harus misalnya kenapa membandingkan negara lain seperti yang ada di abstrak itu, begini. Jadi meskipun kalau kita melihat sebelumnya ya, tadi Mas Muzain sudah menunjukkan ada Soekarno Supomo yang di situ mendorong nasionalis komunis. Kemudian ada Islam yang didorong oleh tokoh-tokoh umat Islam. Ada Hatta dan Yamin yang moderat di situ. Tetapi kalau kita belajar sejarah, ternyata kan semua aspirasi yang muncul baik di ruang tertutup dalam konteks BPUPKI, konstituante, sampai pada MPR, pada ujungnya akan ketemu bahwa kita itu harus berpikir dalam konteks kenegaraan. Jadi meskipun tadi ada titik singgung di tiga elemen yang berbeda, tetapi pada intinya akhirnya kita sampai. Nah, ketika amandemen kan juga muncul ya aspirasi untuk mengajukan lagi supaya Islam menjadi dasar negara. Lagi-lagi di situ juga tertolak kan gitu ya. Dan itulah jalan pilihan kita dengan demokrasi itu seperti itu gitu. Nah, jadi kalau di beberapa negara kita contohkan tadi itu mereka resmi menyatakan dalam konstitusinya itu adalah agamanya, di kita tidak disebutkan, tetapi kemudian tidak dinihilkan. terbukti tadi sudah disampaikan oleh Mas Muzazin, ada beberapa undang-undang yang mengatur kepentingan untuk umat Islam di situ ya. Jadi yang kita perlukan, yang kita ingin dorong dalam paper ini adalah bukan pada formalisasi hukum Islamnya, tetapi bagaimana Islam itu sosialisasinya di dalam masyarakat, yaitu salam perdamaiannya di situ ada, konsep-konsep ukhuwahnya, kemudian juga ada permusyawaratan. Jadi tidak perlu kita memaksakan kehendak gitu ya dalam konteks bernegara, karena kita memang plural gitu. Kita beragam. Jadi disitulah ujian ya sebenarnya bagi orang mayoritas ini mau ngapain sih gitu kan. Nah, jadi mungkin dulu Mbak Mary ketika kuliah di tempat kami gitu ya bisa melihat bagaimana dosen memperlakukan teman-teman yang berbeda agama. Saya pun ketika mengajar di Atmajaya juga diperlakukan sangat bagus dengan teman-teman di Atmajaya. Itulah yang sebenarnya Indonesia. Mungkin itu, mungkin Mas Muzain mau nambahkan, monggo. Terima kasih Mas Irfan, saya kembalikan. Terima kasih Mbak Mary.
Thank you,
responnya.
Prof. Okay, Mr. Muzain, maybe you can increase the explanation.
I don't want to answer technically all question because it will be answered by Prof. Nikmatul Huda. I just want to check the conclusion by stating this fortunate condition that Indonesia never trapped to what we say, the social conflict of after democratization. All countries, especially Muslim countries, are in religious conflict after democratization process. Am I right? Such as Libya, Iraq, Afghanistan, and so on and so on. Why this happen? Yeah, because we have three fortunate conditions at the time. We have in Indonesia we have the middle path religious movement, religious organization, Muhammadiyah and Nahdlatul Ulama, who teach a middle path of Islam. Yeah, in NU we say moderation in Islam from Kementerian Agama. In Muhammadiyah they say the middle path of Islam, and we have this Islamic organization with keep the Indonesian, with keep Islam in Indonesian is still in the middle path, not too radical, not too liberal, yes, in the middle path of Islam. And the second fortunate condition, because the military, military wisely back to their barak after the democratization. Unlikely in Egypt, for example, the military is not give the opportunity to the civilian to take the power, take the control of their country. In Indonesia, the military forces wisely back to their barak. And the third, we have Pancasila. This is the fortunate condition why we passed from the social conflict after the democratization in 1998. Pancasila in one condition become a political compromise between Islamization and secularization, between Islamist nationalism, Islamic nationalism, and also between the secular nationalism. We Pancasila in the middle sense of nationalism. I think this is our concluding remark from this presentation. Thank you, Mbak Mary, for the insightful respondent. Thank you, Bu Prof. Nikmah and Pak Dr. Irfan Nur Hakim.
Okay, thank you. I would address the belief in one God. It cannot be interpreted in grammatical meaning based on the Prof. Nikmatul Huda explanation, but it must be seen in the contextual meaning appropriate with all religion in Indonesia. Jadi it must be interpreted with appropriate with all religion in Indonesia. And then the second, formalization of Islam is so important, but is the most important thing is we have to focus to implement the values of Islam. So it's the most important for all. Okay, thank you very much for presentation, Professor Ni'matul Huda and Mr. Muzain. We will continue to the second speakers. The second speakers is Mr. Zainal Mutakin from UIN Raden Masaid Surakarta, Indonesia, and will be presenting the paper which topic is the impact of Indonesia Constitutional Verdict number 97/2016 on the civic registration of the followers of indigenous religions. Okay, are you ready, Mr. Zainal Mutakin?
Yes, can you hear me clearly?
Okay, it's clear.
Okay,
time is yours. The time is 15 minutes later.
Okay. Thank you, Dr. Evan Rahman, as moderator, for giving me
time. And thank you for the committee who give me opportunity, this honorable opportunity to present my paper in this prestigious symposium. Distinguished speakers and all the participants, I'm also glad to see my former student, Mas Muzain Ahya, one of my best students here. It's been like 10 years after he graduated from this university, and we haven't seen each other. All warm regards from your lectures here, and we all wish you best luck. Okay, in this opportunity, I will present my paper under the topic the impact of Indonesian Constitutional Court Verdict number 97/2016 on the civil administration of the followers of indigenous religions. Next. Next, please.
Yeah. Indigenous religions and their followers, I will call them penghayat from now on, have been the object of discrimination of their civil rights due to the absence of state recognition. The state only recognizes 6 religions, namely Islam, Protestantism, Catholicism, Hinduism, Buddhism, and Confucianism, while indigenous religions and some others like the Baha'i, among others, are not recognized by the state. Next. Indonesian Constitutional Court Verdict number 97/2016 actually gives hope to the followers of indigenous religions for further recognition, in which the verdict corrects 2006 law on civil administration, especially Article 61.1 and 64.1, which this article is actually a good development for the penghayat, for the followers of indigenous religions, because they do not anymore obliged to choose and fill in the column of religion in the national ID or KTP with one of the 6 official religions. The penghayat may leave the column blank. Thus, the verdict amends the law by allowing penghayat to declare, to state whether they use aliran kepercayaan or kepercayaan terhadap Tuhan Yang Maha Esa in the column of religion. So they are allowed to state that instead of leaving the column blank. Next. In this paper, I will examine the impact of the verdict to the civil administration by the penghayat. I will look particularly at the data from government agencies before and after the verdict and see whether the penghayat take benefit of the verdict in civil administration. The first data to consult is the result of the 2010 National Census by Indonesian Statistic, or BPS. I compare this data to the data of civic registration administered by and coordinated by the Ministry of Internal Affairs, Kementerian Dalam Negeri, through their agency in the provinces from 2017 to 2020. like Dinas Kependudukan and Catatan Sipil in the province. I took samples from 2 provinces, namely Central Java and Central Borneo or Central Kalimantan. Unfortunately, for some reason, PPS does not provide data regarding the numbers of followers of religions in the 2020 national census, so that I cannot make comparison between the 2010 and 2020 national census data. Next. Okay. Yep. According to the data of the 2010 national census, the Indonesian population was around 237 million something people. Unfortunately, in the case of religions that Indonesians adhere to, indigenous religion was not available as one of the options in the census. The available choice was to put others or yang lainnya if people feel that they are not accommodated in the 6 official religions recognized by the state. Other options people can choose was not answering the question about their religion or tidak terjawab. There is also data for those who were not asked or tidak ditanyakan about their religions. But there is no explanation whether this was intentional by the surveyor or by accident, why the people were not asked. And from the data, there were like 299,000 something people who claim to belong to others or lainnya, in addition to 6 religions that are officially recognized by the state. There were also 139,000 people who did not answer the question about their religions, and another 757,000 people who were not asked about their religions. To sum up, there are around 1,196,000 something people who are not included as the followers of these 6 official religions, which represent around 0.5% of Indonesian population. However, this percentage will reduce to only 0.13% if we refer to those who opted to others as penghayat. So this paper will categorize only those who choose others as penghayat. I will have argument on this when we take sample in the Central Borneo province. So this research does not take all population as data. Instead, I take samples of 2 provinces, namely Central Borneo or Central Kalimantan and Central Java. These 2 provinces are chosen because Central Borneo have significant numbers of penghayat, as we shall see later, and Central Java is a home for several organizations of penghayat such as Persada, Sapodarmo, Medal Urip, Kapri Badan, etc. Okay, let's start with Central Borneo. Okay, next. Based on the 2010 national census, there were 138,000 something people who identified themselves to the category of others or yang lainnya. Compared to the Central Borneo population of around 2,200,000 something, penghayat represent 6.26% of the population. This number is a lot bigger than those who identified themselves as adherents of Catholicism, which is around 58,000 something people, Hinduism, which is around 11,000 people, Buddhism, which is around 2,000 people, and Confucianism, which is around 400 people. However, according to the civil registration in the government of Central Borneo province, the numbers after the 2016 ICC verdict are just a very small fraction as presented below. You can see from the table that penghayat comprise only around 1,000 people. But in the national census, as I said earlier, it's around 138,000 people. Okay, next slide, please. Yep, let's see the whole data. So where are the penghayat going? Yeah, for your information, until 2017, the Central Borneo province still called penghayat as in the category of others in their data of civil registration. From the numbers
from the numbers above, it seems that others in 2017 consists of Confucianism and Penghayat. You can see from the green in this slide, which is green color. When we add in the 2018 data, so there is around 1,200 others and 200 from Confucianism. So it can be around 1,300 something others in the 2017 data. Since 2018, however, the province started to name kepercayaan kepada Tuhan Yang Maha Esa, believe in the one and only God, as well as put Confucianism as new categories to replace others. So we have now 7 categories, six official religions, and the others is kepercayaan kepada Tuhan Yang Maha Esa. This is a good indication that the province and lower level of government began to acknowledge Penghayat and Confucianism as independent identities in addition to the previous 5 official religions. And the question is, where are the Penghayat going? From the data, most Penghayat in central Borneo seem to identify themselves as Hindus. Okay, let's see. In the 2010 national census, which is the blue color, the Hindus population was only 11,000 something, whereas others category reached around 138,000 people. However, from the 2017 to 2020, the numbers of Hindus are more than 150,000 people. Meanwhile, those who identify as Penghayat are only around 1,000 people. Adding together the category of others and the Hindus in the 2010 national census, we have around 150,000 people, which is close to the numbers of Hindus in 2017. This is why, as I said earlier, those who chose the category of others in the 2010 national census were most likely Penghayat. Okay, then we move to the second province, Central Java. Based on the 2010 national census, there were around 5,600 something people who identified themselves to the category of others. Compared to the Central Java population of around 32 million people, Penghayat represent only 0.02% of the population. This number is far below the adherents of other religions. The numbers after the ICC verdict, according to the civil administration in the government of Central Java province, are increasing. Yet, when it is compared to the whole population of Central Java, the percentage is the same as before the verdict, as presented in the table below. Okay, so it's around 7,000 people from 2017 to 2020, which is from, if we compare to the 2010 national census, it increases like around 2,000 people who consider themselves as Penghayat. Central Java province also acknowledge kepercayaan kepada Tuhan Yang Maha Esa as independent category and not put others in the civil administration. So what we see from the Central Java is the data from the 2010 national census and from the government is not much different. This is different from Central Borneo, which has a quite big gap between the data from the 2010 national census and from the government regarding the followers of the Penghayat. Okay. And then we come to the discussion. Therefore, some may ask why the data from the 2010 national census recorded more Penghayat than what the government administered even after the 2016 ICC verdict. There are some possible answers for the question. First, there is no consequences of the census. People can freely state what their religions are. So to say, numbers are numbers in the national census data. However, it is quite different in the civil registration. When the Penghayat openly identify their religions, their religious identity will partly determine their exercise and access of civil rights. Most, if not all, forms for accessing social services, such as school, hospitals, marriage, electricity, water, etc., have the column of religion which people are required to fill in. Refusing to fill in the column or leaving it blank will probably deny people to get the services. Even worse, failing to fill in the column will make the penghayat face social punishment from the society, such as being stigmatized as atheists or communists, which is bad for them. To simply put it, they are not sure if they fill in the form as penghayat, they will be properly served as like other citizens. In regard to this, the second reason is that most penghayat are still in doubt whether acknowledging of being penghayat in any kind of civil registration might be a good option to choose. Not only do they not be properly served as a citizen, their fear of being discriminated and persecuted, partly because there still exists rules and regulations such as Undang-Undang 1965, Undang-Undang Kejaksaan number 1624, especially these articles, and also Undang-Undang Kepolisian, and the existence of Bakor Pakem. Bakor Pakem is the coordinating board for monitoring belief group, Badan Koordinasi Pengawasan Aliran Kepercayaan Masyarakat. This all regulation and the existence of Bakor Pakem still see the penghayat as deviant groups that should be watched and suspected of potentially disturbing public order.
Mutakin.
Okay. Yeah.
Could you continue to the conclusion?
Okay. Thank you. Yeah. Okay. I will read the conclusion.
2 minutes. Okay.
Okay. Thank you. Okay, unfortunately, there is no immediate impact of the ICC verdict on the civil registration of the penghayat. Some factors discussed earlier should be addressed simultaneously to give them opportunity to freely and openly state their religious identity. There are two important steps. First, to synchronize all rules and regulations regarding the penghayat. Second is to amend rules and regulations that discriminate them or even abrogate the rules. And my suggestion for the research are needed to examine this issue by consulting the result of this paper to the penghayat, to the followers of indigenous religions, to understand their reluctance of registering their religious identity in the civil administration. Okay, thank you very much. I give the time to the moderator.
Okay, thank you very much for a fruitful presentation, Mr. Zainal Mutakin. Unfortunately, we have to finish this session earlier. I just call reserve for the committee because there will be another agenda. So in this last session, I would say thank you for the speakers, respondents, and all the participants. I return to the MC now. Thank you.
Thank you very much, Dr. Irfan Nurrohman. Honorable speakers, distinguished participants, ladies and gentlemen. We apologize for having to continue to the closing ceremony of this 4th Indonesian Constitutional Court International Symposium. Thus, I would like to respectfully invite the Secretary General of the Constitutional Court of the Republic of Indonesia, the Honorable Professor M. Guntur Hamzah, to deliver the closing remarks of the 4th ICCIS.
Thank you, Mary. Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. My peace be upon us all. Om Swastiastu, Namo Buddhaya. the Honorable Chief Justice and Deputy Chief Justice of the Constitutional Court of the Republic of Indonesia, the Honorable Justice of the Constitutional Court of the Republic of Indonesia, distinguished speakers and participants of the International Symposium, ladies and gentlemen. Let us offer praise and gratitude to the Almighty God who has bestowed upon us His blessing and grace so that we can attend the closing session of the 4th Indonesian Constitutional Court International Symposium this afternoon in Indonesia time. I hope everyone who is attending this symposium is still in healthy condition. Distinguished speakers and participants of the 4th ICC-IS. During the plenary and panel session of the symposium, we have discussed a very fascinating topic that has attracted many academics, practitioners, and policymakers under the theme Constitutional Court, Religions, and Constitutional Right Protection. 28 speakers and have conveyed various ideas and opinions to which the respondents and participants of the symposium addressing comments, feedback, and critical questions. One of the fruitful and interactive discussions was regarding several case law decided by the Constitutional Court and the Supreme Court related to constitutionalism and the protection of religious freedom in many different countries, such as Indonesia, Malaysia, Turkey, and Bangladesh. In addition, there was also an interesting discussion of the effect of the Indonesian Constitutional Court decisions towards Islamic law reform, the practice of the constitutionalism and religions in the South Asia region, and freedom of religion in Europe. This international symposium has opened a discourse regarding issues that have received little attention from constitutional law scholars with comparative constitutional law studies concerning courts, religion, and constitutional right protection. Distinguished speakers and all participants. The Constitutional Court of Indonesia believes that investing in human resources, especially for the court staff like researchers and law clerks, will make the Constitutional Court even better, both in case management and the decision-making process. We always strongly encourage researchers and employees at the Constitutional Court to uphold academic values, which can provide substantive support to constitutional justice. In order to improve academic collaboration, the Indonesian court is also very open and welcome to establish a new collaboration with other universities and research institutions where speakers and participants in the international symposium are affiliated. In a global context, the Constitutional Court has also collaborated with universities abroad. For instance, with the The Hague University and Maastricht University in the Netherlands, Leipzig University and Erfurt University in Germany, Certain University and Newcastle University in Australia, International Islamic University of Malaysia in Malaysia, as well as several international universities and research institutes from other countries, such as Max Planck Foundation for International Peace and the Rule of Law. Moreover, to maintain the academic atmosphere in the Constitutional Court of Indonesia, we also manage an international journal called Constitutional Review Consref. Recently, the Constitutional Review Journal has been successfully indexed by Scopus, the largest abstract and citation database of peer-reviewed literature. It creates the Constitutional Court as only judicial and state institution in Indonesia that manage a law journal indexed by Scopus. In this occasion, please allow me to invite all the speakers and participants of the 4th International Indonesian Constitutional Court International Symposium to submit their high-quality manuscript to the Constitutional Review Journal. Therefore, your opinions and ideas can also be read by constitutional justice and other international scholars interested in comparative constitutional law, the Constitutional Court decision, and the human right protection. Given that one of the visions of the Constitutional Court of Indonesia is to establish a modern court, we also welcome article discussing the implementing of the court technology. In this disruption era, the outdated method must be replaced with the application of advanced technology, including in the judiciary. I also encourage the speaker and participants of the symposium to continuously support the implementation of constitutionalism, the rule of law, democracy, and the human rights that can be a blessing to all human beings, nature, and the environment known as rahmatan lil alamin in Islamic law. I would like to end these closing remarks by thanking all parties who have contributed and provided support for the success of this international symposium. Hopefully, this global academic forum can be inspiration and a trigger for further in-depth discussions. I hope we all can meet again in international symposium next year. Thank you for your kind attention. By saying Alhamdulillahi Rabbil Alamin, I close the 4th Indonesian Constitutional Court International Symposium. Wassalamualaikum warahmatullahi wabarakatuh. May peace be upon us all. Om Santi Santi Om Rahayu for all. Thank you so much.
Thank you very much, Professor M. Guntur Hamzah, the Honorable Secretary General of the Constitutional Court of the Republic of Indonesia. By the delivering of the closing remark, that's the end of our symposium. This is the end of the 4th Indonesian Constitutional Court International Symposium, but this will not be the end of ICCIS, because we're gonna be back again next year, of course, with the 5th of Indonesian Constitutional Court International Symposium with brighter and broader topics, and it's gonna be more fascinating, hopefully next year. On behalf of the committee of the symposium, would like to express our deepest gratitude for your participations, your kind attentions, and your response and your support so that the symposium could be held very well these last 2 days of fascinating conferences. Last but not least, wassalamualaikum warahmatullahi wabarakatuh. Salam konstitusi.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Saya Anwar Usman, Ketua Mahkamah Konstitusi Republik Indonesia, mengucapkan terima kasih atas kepercayaan yang diberikan kepada Indonesia sebagai tuan rumah penyelenggaraan Kongres ke-5 WCCJ tahun 2022. Sungguh kepercayaan dari 117 negara anggota WCCJ merupakan sebuah pencapaian yang patut kami syukuri. Dengan mengangkat tema Constitutional Justice and Peace, maka penting bagi WCCJ untuk membuktikan kepada dunia bahwa dalam menegakkan hukum, dalam memperjuangkan demokrasi, dan dalam menjaga hak asasi manusia, haruslah dilandasi dengan semangat perdamaian abadi. Oleh karenanya, pada kesempatan ini, dari lubuk hati yang amat dalam, saya memohon dukungan dan mengundang Presiden Venice Commission, Asosiasi Peradilan Konstitusi Asia, Konferensi Peradilan Konstitusi Afrika, Peradilan Konstitusi Eropa, Asosiasi Peradilan Konstitusi Berbahasa Prancis, Peradilan Konstitusi Negara Persemakmuran, Asosiasi Peradilan Konstitusi Eurasia, Konferensi Peradilan Konstitusi Berbahasa Portugis, Konferensi Peradilan Konstitusi Ibero-Amerika, Forum Konstitusi Wilayah Selatan Afrika, Persatuan Peradilan Konstitusi Arab bersama dengan MK Lituania, MK Djibouti, MK Republik Dominika, MK Italia, MK Aljazair, dan Sekretariat WCCJ. Sebagai duta-duta penegak konstitusi dan duta-duta perdamaian untuk dapat berjalan beriringan dengan Indonesia, mensukseskan Kongres WCCJ, dan turut menjaga ketertiban dunia. Akhir kata, saya tegaskan bahwa Indonesia akan berupaya semaksimal mungkin untuk menjadi tuan rumah yang baik bagi seluruh anggota WCCJ. Terima kasih dan semoga kita selalu diberikan kesehatan dan kekuatan dalam menghadapi pandemi COVID-19. Sampai jumpa di Bali. Wassalamualaikum warahmatullahi wabarakatuh.
What comes to your mind when you hear about Indonesia? If you think about one those things, then you are correct. As an archipelago state, Indonesia is an example, proving how peace is maintained amidst of differences. To let you experience the harmony in diversity of Indonesia, I gladly announce that the 5th Congress of the WCCJ in 2022 will be held in Bali Island, which is also known as the Island of Gods. Bali had the tremendous experience of so many international conferences. In addition, the Indonesian Constitutional Court has also taken various preparation, coordination, and ongoing works such as first convey to the President of the Republic of Indonesia regarding the appointment of the court as the host of the 5th Congress, and kindly ask the President to officially inaugurate the Congress in 2022. Second, communicate with the House of Representatives, Ministry of Finance and Ministry of National Development Planning regarding the financial budget of the Congress. Third, coordinate with Indonesian National Police, Ministry of Foreign Affairs, and other parties to guarantee the permit and security of the events. And the last but not least, internally, the court has also formed the organizing committee and conducted a series of meetings, coordination, and preparation as the road to WCCG Congress. We remain hopeful that the COVID-19 pandemic will be completely gone to be the time of the Congress in 2022. If certain standards are still required in the implementation, we will ensure to obey the health protocol of COVID-19 by the WHO for your maximum comfort and safety. I believe that the Congress in Bali will bring a significant outcome to the enforcement of Constitution in the world level. Therefore, we will provide a cultural programs which can bring a fresh mind for the participants. And finally, in case of unfortunate situation due to the global pandemic, we still be ready to host the Congress with a hybrid method combining on-site and virtual meeting. Thank you. See you in Bali. See you in the 5th Congress of the WCCG.